Welcome back to Court TV Live. I'm Ted Rollins on a Wednesday morning. It's a big Wednesday in Milwaukee, Wisconsin. Closing argument day in the Theodore Edgecomb case. Theodore Edgecomb, accused of murder. He claims it was self-defense when a road rage incident ended with the death of Jason Cleereman, a local immigration attorney in Milwaukee, Wisconsin. Cleereman's wife was in the vehicle, witnessed her husband being shot once in the head. Theodore Edgecomb left the scene afterwards. And there were a couple things on cross-examination and in direct when the defendant yesterday took the stand that perplexed many court watchers. One of them was the way that Edgecomb talked about self-defense. It was a bit muddled, to be accurate. He didn't come out and say, I feared for my life and so I shot him. He said, in fact, that the gun just went off. The other thing that he had trouble with, some people believe, was his explanation of why he fled, especially on cross-examination. Take a listen.
You fled from the scene, correct?
From
homicide scene. You fled from the scene, isn't that correct? Yes or no, sir?
I was only able to get away from there, dude.
So you fled from that area, isn't that correct?
Yes, I did leave from that scene.
Thank you. And then you fled from the state, isn't that correct?
Yes.
And then you ditched the weapon that would have linked you to that shooting, isn't that correct?
Yes, nice and nasty. Overruled.
You can answer it.
Can you repeat that?
You ditched the weapon that would have linked you to that shooting, isn't that correct?
I didn't want to be...
Sir, you ditched the weapon that would have linked you to the shooting, yes or no?
Can you expound on ditch?
No, sir, that's the question. Did you or did you not throw the weapon that would have linked you to this homicide out the window?
I reacted to, to prevent myself from being harmed.
All right, still with us, Aaron Nelson. He's in Milwaukee, Wisconsin. Vonda Sargent is in Seattle, Washington. And this part of the cross was frustrating to watch. I don't know how it translated to jurors because it wasn't in the courtroom. But Aaron, is this something you bring up in your close if you're the state saying, you heard him, he wouldn't answer the question about why he left? Is this to remind maybe jurors of that frustrating feeling that they may have had?
Yeah, I mean, it's hard to place myself in the position of the state.
I should have asked this to Vonda because neither one of you two can play this game. You got to go with your gut. So let's do this. Yeah. From a defense standpoint, how do you explain it if you're up there? Are you going to get up there in your close and address that and the inarticulation of your client in terms of the self-defense? Is that something that you are going to address directly with this jury?
Yeah, I think you need to. I mean, the judge is going to read to them an instruction about flight and how that applies to consciousness of guilt. I think you need to give an explanation as to why it is that he left the scene, why it is that he left the state, why it is that he, as the prosecution said, ditched or threw out the weapon. You might choose different words if you're the defense as to what was happening. And I would emphasize that yes, Mr. Edgecomb had trouble answering those things, but he's an average citizen here being cross-examined vigorously by the state in a way in which he, I thought, raised his voice and did some other things. So, but you're going to need to address that. I think there's ways to address it, and I'm sure whoever gives the closing for the defense will do so in a persuasive way. Whether it's persuasive enough, I guess that's what we have to find out. But I think the best argument to say is let's focus on the facts of the actual shooting as opposed to what happened afterwards.
Vonda, Aaron just brought up Grant Hubner in his demeanor, the prosecutor in this case, during the cross, and it was a bit aggressive. We see that a lot. You know, the voice gets raised up and it's kind of the staccato back and forth trying to really hammer away. How do you then follow that up with the defendant's evasiveness, do you bring that up and hammer that home and saying, I tried to ask him, you heard me, but he wouldn't answer?
Yeah, absolutely. You definitely want to bring it up. And what I would, in my own defense, if I had to use that level of aggression as a prosecutor, I would beg forgiveness from the jury for having done so, and then explain to them why I did that. And I would go into the fact that the defendant was being evasive. You saw him on direct examination, and he answered questions clearly, cogently, without any uh, need for repeating of the question. And when I got up, all of a sudden he couldn't understand the most basic English words and couldn't string a sentence together. So I would definitely do that if I had lost my cool or got aggressive the way that the prosecution did in this case. And I'm glad that I wouldn't be facing Aaron, because Aaron is bringing up some things. I'm going, oh my goodness, yeah, that'd be a hard argument to overcome. So hopefully they will somehow, through osmosis, the prosecution will grab a hold of some of Aaron's arguments this morning.
We'll see how that works out. The osmosis. He is in Milwaukee, after all, so it's not too far away. Aaron, then again on the defense, the problem with the self-defense, are you going to get up there and give a version of what you have to, right? You have to embrace what he said on the stand and continue with that narrative, even if it's different from your open. Here we are, and everything's changed.
Yeah, I think you need to. But if I recall correctly, the defendant did say at some point that he fled for his life. He feared for his life. Now that may have been before, when he was on the bicycle. That may have been when the car was chasing him down. I would emphasize that that's not a feeling that goes away quickly. That this is an event between the time that he's on the bicycle until the time that the shot goes off that is very short in time. And we did get him to articulate that he felt a fear for his life. And I think in that moment on the bicycle, when you're being chased down by a car, it's a better argument to say that that's reasonable. But to say that that continues, to me, that's a basic human experience. If I felt something that strongly, that I was that afraid, it's not going to be a fear that goes away in 5 seconds or goes away in 10 seconds, especially when the pursuit and the chase continues on after. Why else would somebody be getting out of a car? Why else would somebody be coming towards you? Why else would somebody be using the racial slurs that that person was using? And so the fact that he didn't articulate it in that moment of time is certainly a problem. But I think the human experience would lead me to believe that that feeling that he had continued from 5 seconds before.
Yeah, that makes sense. And then the other argument with the Cleereman and that feeling of getting hit in the face, that continued on through the pursuit, which then could change the self-defense in that you can't start a fight and then finish it with a gun. We'll have to wait and see how all of this will be handled in the close. Both sides will have an hour and a half. The judge has allowed them 90 minutes apiece total. He says he's going to cut them off, a firm cutoff at the 90 minutes, so giving them both ample time to get across everything that they see fit in front of this jury in closing arguments. We'll get another break, and we were just told that this 2-minute break turned into a 10-minute break. I don't know if there's printer problems or what, but they're waiting for those jury instructions to be printed so the judge can read them to jurors. We'll watch that next, and then it'll be time for the closing arguments. Stay with us. Welcome back to Court TV Live. We are awaiting the judge and the jury to enter the courtroom so that Judge Brodsky can read them the jury instructions before both sides get up and deliver closing arguments in the Theodore Edgecomb case. Edgecomb, of course, is facing a homicide charge. He claims it was self-defense, his encounter with attorney Cleereman back in September of the year 2020. One of the key witnesses in this case was the wife, the widow of Jason Cleereman. Evangelina Cleereman took the stand and gave the jury a different rendition of what happened than Theodore Edgecomb gave. Let's bring in our two guests this hour, former prosecutor and trial attorney Vonda Sargent and criminal defense attorney to his core, Aaron Nelson. He's in Hudson, Wisconsin. All right, Mrs. Prosecutor, how are you going to address in your close Evangelina Cleereman's at some times unclear testimony in terms of the amount of alcohol she says her husband consumed, which the defense made a big deal out of? I don't know if that will work out in their favor or not, but it was not the cleanest testimony, and she did a little bit of the what we saw with the defendant too on cross-examination. Do you address her if you're the state?
You know, I would raise and dismiss her testimony, and I would do it under the cloak and the veil of being a very distressed widower, not through any natural means, but through an act of violence, and being confronted with a situation that nobody would ever see themselves in their lifetime, and then having to face the specter of being on the stand and answering a series of questions that are designed to discredit her. And I would be done with it and let the defense attack and try to belittle her and come back on my my rebuttal closing and point out what they were doing and make her a second victim is how I would handle that testimony.
And Aaron, that is a trap that the defense could absolutely walk right into. They in the open they went after her. Do you think they'll do the same in the close, and should they?
Yeah, I don't know what they will do. That's definitely something that every attorney has a different style. You know, my approach would probably be a lot softer in that situation. This is somebody that had to watch somebody that she knows and loves go through a horrible experience, and she's
Aaron, I'm going to cut you off.
role
The judge is back on the bench, and let's listen in here.
So can I characterize it as reluctantly stipulating to the instruction on negligent homicide? Yes. Fine, because as I said off the record, I was not going to give it. I think the decision in Watkins, which I glanced at yesterday and had a bit more time to review while we were off the record, is a different situation. But if the state's stipulating, fine, I'll give the instruction on negligent homicide. Now I think we've reached a point where literally the jury can consider every form of homicide that exists in the Wisconsin statutes, correct? Am I missing one?
Felony murder, you're missing felony murder. I'm not asking for felony murder. So
Well, please don't, because we've already given 5 of the 6 possible homicide instructions that exist in Wisconsin. I'd like to not set the world record for lengthy jury instructions. Mr. Mott, I hope we're done discussing this. Is there another issue?
The last issue, placing on the record, state's objecting, but I think if we're doing the negligent, then the accident 772 should be given. I know this. The accident 772 instruction should be given based on what was elicited in cross. That's, I know the state's objecting to that.
Mr. Hubner.
Your Honor, accident is him trying to state, the defendant trying to allege that he did not have the mental state in order to commit the negligent. If their whole point is that it was criminal negligence.
I'm not clear what the point is at this point. Maybe it'll be illuminating to listen to the closings, and the jury is the ultimate arbiter. The jury will consider the evidence. The jury will render a verdict. But I'm extremely confused by the point the defense has been trying to make. They tried to make one point for an entire 6 or 7 days. Then their client took the stand and basically changed what was being implied, if not directly argued to the jury. Mr. Edgecomb did everything he could yesterday to say the gun just went off. So I'm not clear what point the defense is making. Maybe we'll find out at the closings.
Anyways, I don't think accident applies with this fact pattern. It applied in that other, in the case the defense is referring to. It doesn't apply to this. The defendant is not disavowing the mental state. In fact, he's in fact stating he had the mental state, especially based on his weapons training. So therefore, sorry, I'm trying to get to
I don't blame the state. By the way, gentlemen, we discussed a lot of this yesterday. We spent 45 minutes on instructions yesterday.
I need to get a quick break in. The headline, negligent homicide, is in. It's now in as an instruction. More when we return. I'll have the close and the instructions. Stay with us. Top of the hour, welcome back to Court TV Live. I'm Ted Rollins, glad to have you along with us on this big day in Milwaukee, Wisconsin, where both sides will have that final opportunity to address jurors in the Theodore Edgecomb case. It is closing argument day. Right now, the judge is getting ready to read jury instructions to the panel once they walk into the courtroom. After that, both sides will have 90 minutes to try to convince this jury to see their side of things before they begin the deliberation process. The jury has been called for, according to our team in the courtroom, and as soon as they are settled in, we will take the jury instructions live. Always fascinating to listen to the judge instruct the jury, and you think about being in that seat as a juror while the judge is reading it. Aaron Nelson is with us, and Aaron, need to get your reaction. Negligent homicide, the state says, fine, let it in, and the judge reluctantly is going to read it. How big of a win could that be?
Yeah, wow, that's huge, right? Depending upon how the judge, how the defense plays that in their argument, that could be a very compelling position and something that would be a compromise that they could allow the jury to say. And so it's not, it changes from obviously what their defense strategy was earlier, but something they could argue is, look, this is our first time we've given the argument. We're like you, the evidence came in based upon the evidence that you have before you. Here's the options that you have, and negligent homicide is certainly one of those. So that would significantly reduce the maximum penalty and the time here. And if the jury's looking for a compromise, wow, that's a big win for the defense.
Yeah, if they could get them to that point, and it might be that situation where, as you take a look at Theodore Edgecomb there, it'll be just a matter of hours before the jury begins the deliberation process into his fate. And they have a huge menu on their plate, the jury does, in terms of decision making. 5 different homicide counts, if you will. Let's go in, the judge is addressing the jury.
Sure, over the course of the last week plus, at times you must think, geez, Borowski cannot tell time, because I said you'd been around 9 and it's more like 10. We've been discussing a few things, discussing the jury instructions. I'm going to read you the jury instructions. The jury instructions are frankly rather lengthy. They're somewhat, if not complicated, at least involved. So I don't expect you to memorize them. You don't have your notepads. You don't need your notepads. There's no way you can memorize them. Rain Man couldn't memorize them, okay? So you will get a copy of the instructions when you deliberate after the instructions and the closing arguments. Ladies and gentlemen, members of the jury, as I've said, I will now instruct you on the principles of law which you are obligated to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law that I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and judgment, reach your verdict. If any member of the jury, if any of you has an impression of my opinion as to whether the defendant is guilty or not guilty, you are to disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the judges of the facts. The court is the judge of the law only. Evidence. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, any exhibits the court received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I have directed you to find. Anything you may have seen or heard outside of court is not evidence. You are to decide this case solely and only on the evidence offered and received during the trial. As you know, in this case, the information charges first-degree intentional homicide, use of a dangerous weapon. It's alleged that on or about September 22nd of 2020 at 1750 North Holton Street in Milwaukee, Milwaukee County, the defendant did cause the death of Jason Cleereman, another human being, with the intent to kill that person, contrary to the Wisconsin statutes. To this charge, the defendant has pled not guilty, which means the state must prove every element of the charged offense beyond a reasonable doubt. Crimes to consider. First-degree intentional homicide, self-defense, second-degree intentional homicide, first-degree reckless homicide, and second-degree reckless homicide. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide or second-degree reckless homicide, or finally, homicide by negligent use of a weapon, all of which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crimes referred to as first and second degree intentional homicide and first and second degree reckless homicide and homicide by negligent use of a dangerous weapon are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant cause the death of the victim. First and second degree intentional homicide require that the state prove the additional fact that the defendant acted with the intent to kill. First and second degree reckless homicide require that the defendant acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Homicide by negligent handling of a dangerous weapon requires that the defendant cause the death of the victim by criminally negligent conduct in the operation or handling of a dangerous weapon. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense. The criminal code in Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use force. Let me back up. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. Provocation. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he or she is in imminent death, strike that, imminent danger of death or great bodily harm, he or she may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he or she reasonably believes that he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. A person who provokes an attack may regain the right to use or threaten force if the person in good faith withdraws from the fight and gives adequate notice of the withdrawal to his assailant. A person who provokes an attack, whether by lawful or unlawful conduct, with the intent to use such an attack as an excuse to cause death or great bodily harm to another person is not entitled to use or threaten force in self-defense. Retreat. In determining whether the defendant reasonably believed the amount of
Judge
force.
Borowski giving the jury instructions to this panel before they listen to the closing arguments. We'll slip in a break here, get you back into court after this. Stay with us. Welcome back to Court TV Live. The judge is delivering the instructions to the jury. This is the last event, if you will, before closing arguments in the Theodore Edgecomb case in Milwaukee, Wisconsin. We saw the defendant take the stand yesterday in his own defense. And today, we're going to hear reaction to that from both sides. We'll hear the defense and the state talk to this jury one last time. There is a sidebar going on right now during the reading of the instructions. Somebody wants to discuss this outside the presence of the jury. So let's bring back in Aaron Nelson. Aaron, jurors, they start listening to instructions, and a lot of it goes over their heads, but they have a copy, as Judge Borowski told them. Let's go back in. It sounds like this was just a quick sidebar to clear something up. Let's go back in and listen to this process.
I just discussed something with the attorneys, obviously, just to clarify it. Let me reread that last sentence and then continue. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first or second degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will then be instructed to consider the last offense of negligent homicide. The facts necessary to constitute each crime will now be defined for you, explained in greater detail. First-degree intentional homicide, as defined in the criminal code, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The burden of proof. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant caused the death of Jason Cleereman. Cause means the defendant's act was a substantial factor in producing the death. Two, the defendant acted with the intent to kill Jason Cleereman. And three, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the action. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances, in this case, bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While a motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all the circumstances. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, one, the defendant did not actually believe he was in imminent danger of death or great bodily harm, or two, that the defendant did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant.
Judge Borowski going through the degrees of homicide that the jury must take into account when deciding the fate of Theodore Edgecomb. If you've watched this trial, think about where would you land on this? First degree all the way down to negligent or not guilty, all on the table for this jury. But before that, we're going to hear the closing arguments, and we will too. Stay with us. Be back after this. The fate of Theodore Edgecomb will be decided by a jury in Milwaukee, Wisconsin. They'll begin that deliberation process in a matter of hours. Right now, they're being instructed by Judge Borowski. He told the jurors it's a little dense, the jury instructions. However, they'll have a copy, and these are the rules of the road for them as they deliberate the fate of Theodore Edgecomb. Edgecomb, you see there live, took the stand in his own defense yesterday. We'll hear what both sides have to say about what he told the jury in the closing arguments. Let's go back in and listen to Judge Borowski instruct this jury.
The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. Your decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of second-degree intentional homicide. And you then must consider whether the defendant is guilty of first-degree reckless homicide as defined in the Wisconsin Criminal Code. This homicide is also a lesser included offense of first-degree intentional homicide. You should and must make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on the charge of second-degree intentional homicide, you should and must then consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant caused the death of Jason Cleereman. Cause means the defendant's act was a substantial factor in producing the death. Two, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death of great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all evidence in this case that the risk was unreasonable. And three, the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed
All right,
utter
as Judge
disregard
Browser continues with the jury instructions, we'll get in another break now. We expect the closing arguments to begin very soon, possibly when we return. So get ready. Be back right after this. fate of Theodore Edgecomb is about to be in the hands of a jury in Milwaukee, Wisconsin. After closing arguments, it'll be up to them as they start the deliberation process. Each side will have an hour and a half to deliver the close. So when will they begin that process? Likely, obviously, after lunch. Let's bring in Aaron Nelson. He's a criminal defense attorney, and he's watching along with us in Hudson, Wisconsin, going through the jury instructions now, and then it will be the close. For you, the night before close, do you get much sleep? And right now, as the judge is going through these instructions, what's going through the minds of the attorneys?
Well, I'm always a good sleeper, so yeah, I get plenty of sleep. But I think it's all about the planning, right? I'm sure they did all of the work. The interesting thing, I think, here is that they got the jury instruction on negligence, and that was given just this morning. So, you know, the work that the defense had to do last night was to prepare probably two alternative different arguments, or at least different ways in which you were going to argue the case, depending upon whether or not you got that instruction. I'm excited to watch and to see what the defense, how they thread this needle, I should say, whether they continue with a self-defense, whether they give an alternative defense to say, if you don't think it's self-defense, you can still do negligence, or whether they throw out the self-defense and just say he wasn't acting intentionally, he wasn't acting recklessly. What he did was negligence and concede to some degree the fifth count of the homicide. So there's lots of different ways that they can go here, and I'm sure they didn't get much sleep having to prepare for all of those different options last night.
Yeah, and now, as you pointed out, preparing another version possibly with this negligent homicide, if they didn't really think it was going to be added, sure, they crossed their mind, but that might change the whole game for them. Along with Theodore Edgecomb's testimony, I'm sure that changed a bit of it as well. Let's go back in and listen to the conclusion of the jury instructions, and then as soon as the judge is finished, we anticipate they'll dive right in to the closing arguments.
Which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant operated or handled a dangerous weapon. Two, the defendant operated or handled a dangerous weapon in a manner constituting criminal negligence. Three, the defendant's operation or handling of a dangerous weapon in a manner constituting criminal negligence caused the death of Jason Cleereman. Cause, again, means the defendant's act was a substantial factor in producing the death. Dangerous weapon. Dangerous weapon means a firearm, whether loaded or unloaded. A firearm is a weapon that acts with the force of gunpowder. Criminal negligence. Criminal negligence means a defendant's operation or handling of a dangerous weapon created a risk of death or great bodily harm, and the risk of death or great bodily harm was unreasonable and substantial. And the defendant should have been aware that his operation or handling of a dangerous weapon created the unreasonable and substantial risk of death or great bodily harm. The difference between criminal recklessness and criminal negligence. Criminal recklessness and criminal negligence both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal recklessness requires that the person engaging in that conduct be aware of that risk, while criminal negligence requires that the person engaging in the conduct should have been aware of that risk. The jury's decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminal negligence in the operation or handling of a dangerous weapon, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. You are not, and these are all important, but this is important, you are not in any event to find the defendant guilty of more than one of those offenses. Use or possession of a dangerous weapon. The information, the charges in this case allege not only that the defendant committed the crime of either first or second degree intentional or first or second degree reckless homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty of any of those foregoing offenses, you must answer the following question. Did the defendant commit the crime of first or second degree intentional or first or second degree reckless homicide while using a dangerous weapon? Dangerous weapon means a firearm, whether loaded or unloaded. Before you may answer the second question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer that question, no. I told you guys these were long. What?
Verdict approved.
In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence.
All right, Judge Browski. He's getting through them, the jury instructions, almost to the end. Let's get the break in now, and then when we return, we'll hear the closing arguments. The state will go first. Each side has an hour and a half to talk to this jury. We'll watch it all right here on Court TV. Stay with us. We're back, and Judge Borowski is still instructing the jury in Milwaukee, Wisconsin. He's getting down to near the end of that stack of instructions that he printed out, and as soon as he's finished, we're expecting to go right to closing arguments. Both sides have 90 minutes apiece. It'll start with the prosecution, then the defense will have an opportunity, and as always, the state gets the last word with this jury. Let's go back in and listen to the end of the jury instructions and the closing arguments.
Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you, the jury, to decide. Exhibits. An exhibit becomes evidence only when it's received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Police reports. During the course of the trial, the lawyers may have referred to or used police reports with witnesses. In most cases, these reports will not be provided to you. If you are not provided a police report, you need to use your collective memory regarding any reference to such report. The weight of the evidence. The weight of the evidence does not depend on the number of witnesses on either side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. The jury's knowledge. In weighing the evidence, you, as the jury, may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Credibility. It is your duty, the duty of the jury, to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. If you believe that any of the parties or the court has an opinion as to the credibility of a certain witness, disregard and do not consider that, as you are the sole judges of the credibility of the witnesses. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the trial, the witness's conduct, appearance, and demeanor on the stand, the clearness or lack of clearness of a witness's recollection, the opportunity the witness had for observing and knowing matters testified about, the reasonableness of a witness's testimony, the apparent intelligence of a witness, any bias or prejudice, if any possible motives to falsify testimony, and all other facts and circumstances during the trial which tend to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. As you know, the defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. You should use the same factors to determine the credibility and the weight of the defendant's testimony that you would use to evaluate the testimony of any other witness. There's not a magic way for you to evaluate testimony. Instead, you need to use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you, and you should do the same thing here. Any remarks or comments by the attorneys are not evidence. If a remark or a comment suggested certain facts not in evidence, you're to disregard that suggestion. Evidence was received in this case that the defendant had other open cases at the time the charged offense was committed. That evidence was allowed only as it pertains to the defendant's credibility and should not be used for any other purpose. Furthermore, evidence was received that the defendant was temporarily restricted from possessing a firearm at the time of the charged offense. While one may be temporarily restricted from possessing a firearm due to court orders, this shall have no bearing on whether the defendant was privileged to act in self-defense. Under the law, the defendant still had the right to act in self-defense at the time of the offense, and you are to decide only whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Finally, evidence was also received that the defendant was on bail at the time of the charged offense. This fact shall also have no effect on your deliberations as to his guilt or innocence as to the charged offense. You are to decide this case solely and only based on the law and facts presented to you during the trial. In just a minute, both sides will make closing arguments. You are to consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. You are to draw your own conclusions from the evidence and decide upon and reach your verdict according to the evidence and under the instructions given to you by the court. At this time, I'm going to ask both sides to make closing statements. I have told both sides that they have a maximum of an hour and a half total each, an hour and a half each for closing arguments. I've encouraged both sides to recognize that they don't need to use that entire hour and a half, and they may be shorter, but they will certainly be no longer than an hour and a half. That's a hard stop from this court for both sides. We'll proceed, certainly start and proceed with the closing from the state. Mr. Huebner.
Can everyone hear me? Okay, good. I see that. Ladies and gentlemen, first of all, I want to thank you for your time and your patience. This has taken longer than what you were told it would. You've listened to over 20 witnesses. You've heard over 100 exhibits. You've watched a video. You've seen me drink about 30 Diet Cokes. You've been here for a long time. And you've been patient. We're here about something that almost boggles the mind on how tragic what happened is. On September 22nd of 2020, two different men were heading out. The victim was with his wife. They went to a bar, they went to the happy hour, and then, because he'd been drinking, he asks his wife to drive. They decide, because it's a nice night, to drive down Brady, and he has his window open. Now, ladies and gentlemen, as you've heard, the defendant, well, he left home. And he left home with that firearm he wasn't supposed to have. He left with that firearm, and he's on his bike. And he's walking originally. Now, ladies and gentlemen, there is an incident that occurs. Ms. Cleereman testified and told you about how, out of nowhere, in between two cars on the north side of the street, the defendant just kind of juts out. Keep in mind, ladies and gentlemen, that all the security video that we have, that we are able to find, shows him walking his bike on the north side of the street. Everything. Now, there has been a lot of discussion from the defense of, well, there's missing video that would have shown him flying up on a hood of a car and all of this, and the bike gets hit. Ladies and gentlemen, he's able to ride that bike for miles afterwards. There's no damage to the bike. You've seen the bike. There's no anything, any evidence to support that there was ever any hit between the car and the bike, anything. Nothing on the bike, no evidence whatsoever. And defense counsel started this trial by telling you how highly suspicious it was that 745 on Casablanca, which would have captured that, is somehow missing. Except, as the evidence shows, that's not true. You heard from Officer Howard, who watched that period. Nothing was there. The Zanya's Pizza, which covers that same area, doesn't happen. So all of a sudden now, we're moving to Gloriosos. Now that's the missing part. And then the defendant takes the stand and says, not even there, further east. Ladies and gentlemen, the police looked for where that incident occurred. They didn't find it. But regardless of it, ladies and gentlemen, all it was a situation in which Mr. Cleereman yelled, possibly swore, and he hurt the defendant's feelings. He wasn't hit, he wasn't injured, there's no damage to the bike, there's no injury to him. And what does the defendant do? I can't let them get away. He gets on his bike and he follows. He follows them. He goes right past the dynamite where he's supposed to pick up the sushi, doesn't care about this special night anymore. He had one thing on his mind. He was irate, and he wanted to catch up, and he sure did. And ladies and gentlemen, his own words to you tell you that this whole thing about him flying up on a car is a lie. Because he says, were you talking to me? He testified, well, he just wanted to see if they were going to admit to hitting him. But that never comes up. What he says is, I want to know if you were talking to me. And then he punches him. He punches the victim straight in the face. He punches the victim, causes his glasses to fly, causes blood to flow. And he gets on his bike, or stays on his bike, and just continues right around that corner. Now, ladies and gentlemen, yes, the victim put his hand on the car door and opened it and then closed it. And yes, he tells his wife to turn. And yes, they pull around and she stops the car. And he, the defendant, is now up on the
We need to
sidewalk.
take a quick break as we approach the top of the hour. We'll pick it up right where we're resuming. We'll resume right where we left off. Chanley Painter's next. Stay with us.
Medical. The call and Medicare benefits review are free.
Just call 800-992-5674 now. That's 800-992-5674.
Hello and welcome to Court TV Live. I'm Chanley Painter in for Julie Grant this afternoon. Thank you for being with us. It's a big day in Milwaukee, Wisconsin. Closing arguments in the Theodore Edgecomb trial just underway. Let's go back inside court where the prosecutor, Paul Hubner, is delivering those closing arguments for the prosecution.
The bike towards those stairs are, and then he stops. And ladies and gentlemen, you saw, yes, the victim starts off with that purposeful walk that several witnesses saw. And then, yes, even though some of them don't remember it, he got into that little bit of a jog. And he gets there and he squares up with the defendant. He's there, ladies and gentlemen, as Jose Perez and Jeff Parr told you, looked like he was going to confront them. His wife even said to the police at the time, yes, she said he was going to talk to him. She told the police he was going to confront him. Confronting could mean yelling at him, asking him a question, could be meaning to fight him, could be doing exactly what Rodtrell Cameron said he was going to do, which was get in that boxer stance. He was going to punch the man, according to Rodtrell Cameron, that had punched him. The defendant threw a punch, and then when that person was getting ready to punch back, according to Rodtrell Cameron and Jeffrey Parr and Jose Perez and the victim's wife, he pulls a gun, aims it at the victim's head, and pulls the trigger. Victim drops. So cold-blooded. Rodtrell Cameron is on 911 saying, "You gotta get here. He's still here." When he talks to the police, "Dude's gotta go. That was too cold-blooded." Now, ladies and gentlemen, when Jason, the victim, gets there, he has nothing in his hand. Nothing. No weapon. There's no evidence under any circumstances, under any view of anything that has been brought into this case to believe that he had a weapon in his hand. Defense counsel made a very big point over the fact that they were going to have a witness that came in and said that somehow the wife was going through his pockets and they were insinuating as though she was somehow putting the knife in. That also came for what seemed like one of the weirdest sidetracks where the defense was attempting to debate whether or not she even loved her husband. Remember that? A wife that purported to love his husband? Oh my God, she asks, is he right? She's so calm. We're spending all this time when the video that everybody knows about shows her in the back of the squad when the shock begins to fall off and the tears start coming and she goes, "Oh my God, my love. No one will love you like me, my love." She is heartbroken. She held it together as long as she could. Maybe you wouldn't have reacted that way. Maybe defense counsel wouldn't have reacted that way. But to question whether or not a woman who saw her husband's brains blown out of his head in front of her even loves her husband because of some tone is disgusting. And then we get this thing of, yes, she's somehow trying to secret the knife. That makes no sense. First of all, ladies and gentlemen, she told you, she went there, she wanted something, she grabbed his wallet. How do we know that? Because the video showed you. She goes to the cops, "I've got his wallet." We know what she was doing. She grabbed his wallet. Does it make sense? I don't know what I would do if my wife's brains were blown out in front of me. No one knows. Defense counsel questions that and makes it seem like somehow she's trying to take this knife and put it in his pocket. Ladies and gentlemen, in order for that to be true, Ms. Cleereman, at that moment in time, would have had to realize, I got to take this knife out of his hand. You know what? Instead of throwing it over the wall or putting it in the car or putting it in my purse, I'm going to put it in his pocket. And then, in order for someone to realize, because there's people around, maybe they see me going to his pocket, I'm going to take his wallet, so that I've got a ready excuse. That's the amount of thinking that they're expecting Ms. Cleereman to have. And they're forgetting one thing, ladies and gentlemen. When he got punched, Mr. Cleereman puts his hand up, remember? And he says to his wife, I'm bleeding. That hand, that right hand, it's got blood all in the palm. That right hand that when he touches, mere touches the car door in order to open and close it, leaves blood on the wall of the door and on the window. So much blood, ladies and gentlemen, that it's literally visible on the car. That bloody hand, in order for defense counsel's point to make any sense, would have had to gone into this pristine pocket by these pants, leaving no blood on the knife or on the pocket or anywhere. Didn't happen. Didn't happen. Mr. Cleereman, according to Rotrell Cameron, gets into a boxing stance, and Rotrell said, I just would have boxed him. But the defendant pulls his firearm, he aims it, he puts one right above his eyes, right above the eyebrow, into the victim's brain, which causes him to drop, a fatal wound. And keep in mind, ladies and gentlemen, what the ME told you about that. Slightly upward, slightly upward. Front to back, no left to right deviation. It's a straight on shot, just like all four witnesses described. Raising his hand with a gun in the hand, because when someone's got a weapon in their hand, you know what it is. You see it. You see that weapon. 4 people saw that gun in his hand. Not because it's down by the side and, oh, there's a lot item or they saw the gun because that was the threat and that was the weapon. And Mr. Cleereman takes that bullet into the brain. And what does the defendant do after that, ladies and gentlemen? He runs. He takes off. Instead of taking the direct street there, he ends up taking a bike path in which police would not be able to be driving down. He takes the most obscure way to get to his house where he can't be found or seen by individuals. He gets into the house and he ditches. What does he ditch? The bike. The first thing, the main thing that everyone's saying about who he is the bicyclist. He gets rid of the bike and then he walks and he goes, and all we know is he never comes back. The gun that he used, according to him, he just throws it out the window because he, doesn't want someone to shoot him with it. Something that meant that he kept onto it, held onto this murder weapon for weeks through 2 states until all of a sudden he hits the cornfields of Indiana as though some voice comes out and says, if you ditch it, they won't find you. No, ladies and gentlemen, he's getting rid of the gun 2 states away because he's trying to avoid getting caught. That's why he dyes his hair. That's why he goes on the run. That's why he says he's from the Bahamas and tries every last ditch he can to not be held responsible. And when they come down, he plays dumb in the hopes that we won't be able to put it together on him. And then, ladies and gentlemen, it's all, oh, the victim must have had a knife. And when that falls apart because their witness doesn't see anything in the wife's hands and there's no evidence to support he had anything, not one single witness supports that, all of a sudden, at the 11th hour, we go from, yep, I was defending myself, to it's an accident. He tried to get away. He tried to lie. He tried to play dumb. He tried to say the victim was doing something. And now it's just an accident. Now, ladies and gentlemen, those are the facts. And now you need to consider them in terms of the law. The first count you consider, ladies and gentlemen, is first-degree intentional homicide. The counts and elements are fairly simple. First, did he cause the death of the victim? Clearly he did. He shot him in the head. He falls down almost immediately. It's a mortal injury. It's a substantial factor. The defendant, under all circumstances, is the cause of the victim's death. Did he act with intent to kill? He raises his arm, according to 4 people, and shoots the victim in the face. The gunshot, front to back, slightly upward. That's not consistent with anything the defendant testified to, but it is consistent with 4 witnesses and video that show him with his arm and the victim goes down. And intent to kill means this, and this is very important. Practically certain to cause death. That the defendant knew that when he shot the victim, it was practically certain to cause death. He told you he's got weapons training with all his maritime security. He's gone to the range. He's been taught on how to hit what he shoots at. Well, he did. And when you shoot and aim at someone's head, that is practically certain. He knew that. That is intent to kill, ladies and gentlemen. That is intent to kill. And now we get to how self-defense factors in. The third element of intentional homicide is that the defendant did not actually believe that the force was necessary. Did not actually believe. But this only comes into play if you don't believe he provoked the attack. A person who engages in conduct likely to provoke an attack and who provokes an attack is not allowed to use force against the attack. However, as defense counsel will tell you and as the law says, if he withdraws and he makes it abundantly clear, he can regain that ability. But keep that in mind about actually believing the force was necessary. He is confronted with a man that he punched in the face. That man has no weapon. He has a gun. He withdraws it and he shoots him in the head. He started a fist fight and then he brought a gun to it. He started a fist fight and he brought a gun to it. That's what happened. And that's what he did. He did not actually believe he had to shoot the victim in the face. When the victim said words, he punched him. When the victim gets ready for a fight, he kills him. Every escalation of the violence in this case has come from the defendant. Every time. There is no weapon in the victim's hands. Now, ladies and gentlemen, if, for whatever reason, you believe that the defendant did actually believe the force was necessary and did actually believe that he was acting in self-defense and that there was a threat of unlawful interference.
All right, we have to step aside for a quick break, but don't worry, we'll take you back inside the courtroom for closing arguments from the prosecution in the trial against Theodore Edgecomb. You're watching Court TV. Welcome back. Prosecutor Grant Hubner is in closing arguments against Theodore Edgecomb, painting him as a cold-blooded killer who started a fistfight and then brought a gun to the fight. Let's go back in right where we left off.
Other than his incredible testimony, then, ladies and gentlemen, you go to the next question, which is second-degree intentional. Again, he caused the death, intent to kill. There's no doubt about that. But then we get to do not, whether or not the defendant did not reasonably believe that the force was necessary. And if any one of these three apply, any one of them apply, then the defendant is guilty of second-degree intentional. A reasonable person would not believe he was preventing or terminating unlawful interference. He punches the victim and then shoots him. Keep in mind, this is someone who said he just couldn't let the victim get away. The next one is a reasonable person would not believe he was in danger of imminent death or great bodily harm. When he is looking at the victim, there is no visible weapon. As Retro Cameron told you, he just pulls it and he just shot him in the head. Remember that. On the 911 call and to the police officer, he just shot him in the head. He just shot him in the head. And then he flees. And the last, ladies and gentlemen, is that a reasonable person would not have believed that the amount of force used was necessary. He brought a gun to a fist fight he started. That's not reasonable. If, for whatever reason, you do not believe that there is intent to kill, and you should, because under the law, as we've talked about, it's practically certain to cause death. His training, he knew it, he's been trained, he knows how to hit what he shoots at, and he did well. Unfortunately, in this case, you get too reckless. Again, cause the death, we know about that, but then we get into criminally reckless conduct. Did he create a risk of death or great bodily harm? He shot him in the face. Was that unreasonable? Did he know it was unreasonable and substantial? At a close range, when that individual, the victim, according to Mr. Cameron, according to other people, are just going to confront him, no weapons, no punches, no nothing, he pulls a gun and he shoots him. That is unreasonable. He knows what he's doing. He's been trained. And in this situation, ladies and gentlemen, when you get to reckless homicide, the actual and reasonable belief portions of self-defense apply. It's not like an intentional where if, he actually believes, but it's unreasonable, it's second-degree intentional. In first-degree and second-degree reckless, if you find it to be unreasonable what he did, and you should, then he's guilty of either one of those, depending on how you view the last, and this is important, the last element of reckless conduct, utter disregard for human life. And in this situation, ladies and gentlemen, you are told you consider the defendant's conduct after the incident. He shot a man in the face. That's utter disregard for human life. And the last one, ladies and gentlemen, homicide by negligence, thing that comes out of nowhere. After days of talking about how the defendant was forced out of self-defense to raise the gun and fire it, all of a sudden, after every other thing that has been tried has failed, we now get the gun was pointing down, all of a sudden the guy's spearing him and it goes off. Except the ME and the witnesses show that that's not what happened. He doesn't get slightly upward, front to back, no left to right deviation, except for in the way in which 4 people said it. Pulls the gun, without warning, without anything, and he just shot him in the head. Ladies and gentlemen, in the beginning, defense counsel came up and he said, you see my hand, you see everything, you see everything about my hand. Well, someone did see all portions of a hand. The defendant saw the victim's hands. There was nothing in them. And he shot him. No weapon. Just a man who's confronting the defendant after the defendant punched him in the face. For that reason, ladies and gentlemen, he's guilty.
Okay, hang on one second. Carol, do you need a break? All right, defense, proceed.
Okay, it seems as though they are taking a break in the courtroom. That was the prosecution's opening statement. Unclear if it's the end of it or if he'll keep going. I noticed that he did sit down there inside the well of the courtroom, but in the meantime, let's bring in Jack Rice, my legal analyst guest, to talk about what I think is a really dynamite closing argument for the prosecution here. Jack, what do you think?
Yeah, I agree completely. He brought a gun to a fight he started. He's now said it 3 times. And it really is the theme of his case. And so what he's really trying to do here is to establish he's the guy, Edgecomb started this, Edgecomb was the fighter, he's the one who started it once, he came back again, there was nothing else. He's doing a very good job. And by the way, he's closing up the gap that Edgecomb is going to try to argue that basically Cleereman was chasing him and got into that stance. If you can close that gap and say, this is the same incident, it's all Edgecomb's fault. That ability to push this from not just the reckless second or even first degree into the intentional homicide really gets closer and closer when you make that argument.
I agree with you, and he really has kept his story succinct, starting out with the incident, painting his version of what happened, and then goes into what the defendant did after the shooting, that flight as consciousness of guilt. That's a strong piece of evidence for this prosecution. And then I also liked how he's walking the jury through the counts that they will consider when they do begin deliberations, starting with the top count. And his tone is as if you don't need to go look any further than intentional homicide because this, and this. Did you think that was effective? I didn't really like the notepad, but other than that, did you think that that was also effective?
Boy, I agree with you on the notepad piece, right, Chanley? I mean, when I think about these, one of the things I'm always talking to other lawyers about when I'm teaching or whatever else is really about this need to not have notes, because it needs to feel visceral. It needs to feel like you're just exploding this out for that jury, and so they feel it in the very same way. I think one of the things that he did that really worked was he started out by slapping away at all of the potential claims of the defense, right?
Yes.
And so he does that first, and then he turns to the law. And he starts talking about what happened, how it worked, how it applies. I think that's really effective because in trial work, there's something called primacy and recency. The idea that you remember the first things you say, you remember the last things you say. Sometimes people don't remember the stuff in the middle. But when you do that, it's something that a jury will hold on to and say, yep, I remember when that prosecutor said this. That's really important.
It is a repetition, and he is doing that. He's moving about the well of the courtroom, just confident, commanding, and that's what you need, because I know these defense attorneys are going to come armed, Jack, as well. They are also excellent, energetic, and powerful, so I'm sure that he's trying to anticipate that. But we have to squeeze in a quick break. Jack, thank you for being with me and helping me analyze this important day in the trial of Theodore Edgecomb. Again, closing arguments underway. We'll get you back inside the courtroom as soon as court resumes here on Court TV Live. Thanks for being with us this afternoon on Court TV Live. I'm Chanley Painter, where closing arguments are happening in the trial of Theodore Edgecomb. He faces intentional homicide charges in the death of immigration attorney Jason Cleereman in 2020. He claims it was self-defense. Prosecutors in closing so far painting him as a cold-blooded killer who brought a gun to a fist fight. Let's break down so far what we've heard. Court is in about a 10-minute recess right now, and I have Jack Rice with me, criminal defense attorney, to offer his expertise and feedback on the closing arguments. Because, Jack, just remind everyone how important closings are in a jury trial.
Yeah, there's no question about it, Chanley, because when we think about openings, what openings are designed to do is they're designed really to let the jury know what's coming. You need to look at this kind of evidence, but what it really isn't is it's not an argument. And frequently what you're saying during direct and cross-examination of all of those witnesses, it's about presenting pieces of evidence. It's only at this time, only during closings, that you really get to construct your case. You get to put it together and argue about why you're right. And so it's really, really important to be able to take those pieces of evidence and to put them together in such a way that the jury can see the picture, but also the opportunity to dismiss those other pieces of evidence that may have come in from the opposing side. And so you can dismiss those pieces and say, that has nothing to do with what happened here. So this is your opportunity. This is your chance to say, this is why you have spent weeks and weeks here. This is what this is about. And that's actually what this prosecutor is doing very, very well.
He is indeed, and maybe a couple of jurors had some lingering doubts, or maybe it wasn't a complete picture. This is the opportunity, and as we know, prosecutors always get the last word. So if indeed this is the end of the first close, we'll hear from the defense, and then, of course, a rebuttal from the prosecution here. Jack, so far, what we've heard from the prosecutor, what else do you think he needs to do, Mr. Hubner, here to convince this jury?
Well, see, one of the benefits that the prosecution has, and remember, I'm a former prosecutor, I've been a criminal defense attorney for 20 years, is that you have the ability to do the closing, and then you get rebuttal on the back end of the trial. This is frustrating from a defense perspective because you feel like you're being bookended, because you are. And in fact, what the prosecution can do is the prosecution can sort of finish this up, and I would really finish this up with this idea that Edgecomb started the fight, then brought the gun to finish it. That's the closing argument. Then what you do is you watch the defense put on their defense, the arguments, so you can come back and rebuttal to dismiss the negligence piece, that negligence, that fifth count. Then you try to argue away that reckless homicide, first and second, and push this up into the intentional realm. Because if you do that, then you come back and you give the refrain again. You bring a gun to a fight you start so you can finish it. That's what Edgecomb did. That's what I expect to see.
I agree with you, and I do see the judge is back on the bench. Jack, I see the defense attorney standing up. So let's go in, let's listen, let's see we don't miss anything.
All right, jury's coming in. Silence in the gallery. All right, the jury's back. For the jury, we're going to work into lunch. The defense is going to do their closing. The state will have our opportunity to do rebuttal. I've ordered lunch. Lunch will be waiting for you. So we're going to work into lunch, get the closings done, and get the case to 12 of you to deliberate. Defense can proceed.
Good morning, members of the jury. Robert Kennedy once said, "The glory of justice and the majesty of law are created not just by the Constitution, not by the courts, nor by the officers of the law, nor by the lawyers, but by the men and women who constitute our society, who are the protectors of the law, as they are themselves protected by the law." Members of the jury, it's been over a week now. And as the state has pointed out, you know, I've seen you very active and engaged in this case. You've been taking notes. And this is a traumatic situation, you know, for both parties that's involved in this case. This case has been filled with emotions on both sides of this case. And, you know, we really just thank you for just, you know, keeping an open mind as we go through the process. Now, the state just talked about, when we talked about the other side of the story. Remember that? The defense in this case has established everything that we said we would show you on the other side. The state didn't come up and talk about a wallet. You never heard about a wallet in this case. We told you that the crime scene was contaminated. We told you that seconds afterwards, there was tampering of evidence in this case. We promised that we would show it to you. That promise did not come back void. Now we're talking about a wallet all of a sudden. Now, 1.5 years later, there's an explanation for a wallet. Now, the truth of the matter is, no party here knows exactly what took place on September 22nd of 2020, because the state has not satisfied and filled their burden. They haven't proved anything beyond a reasonable doubt. What they've shown is theories. They haven't proved anything beyond a reasonable doubt.
The Ivory Lamar defense attorney for Theodore Edgecomb just getting started on his closing arguments, but we're going to step aside for a quick break. Don't worry, you won't miss a moment of the defense closing here on Court TV. Live, your front row seat to justice. welcome back to Court TV Live. We do have breaking news to report just into our newsroom. Supreme Court Justice Stephen Breyer announced his plans to retire from the Supreme Court. That's according to the Associated Press. Now, the 83-year-old justice has served on the nation's highest court for more than 2 decades. This announcement now gives President Joe Biden an opportunity to fill the seat with another justice. The AP also reports President Biden plans to fill the seat with the first black female justice. All right, that's the breaking news. And of course, as you know, we are live inside the Milwaukee courtroom for closing arguments in the trial against Theodore Edgecomb, charged with the murder of attorney Jason Cleereman. His defense team now making their final arguments to this jury. We're going to pick up where we just left off with his attorney, Ivory Lamar, arguing for his defense.
Knife in the right pocket. Oh, no big deal. As if it takes so long for a folded knife to become a threat. Here's the knife. It's folded. Could go in a pocket very easily. Here the knife is extended. How long does it take for the knife to go from being extended to being folded? Let's find out. Less than a second. Now it's folded. Now, just at the onset here, I want to discuss a couple things with you. You know, you've heard a lot of testimony in this case, and this is a case that, as you can see, just with the coverage of this case, it evokes a lot of passion. You know, this case is, it's a precedent-setting case. You know, this is a rare case that has been presented to you where this time, there's an African-American man who's now using self-defense against a Caucasian man. You don't see that every day. And he's not just anybody. The evidence is so he's not just anybody. He's somebody that's well respected in this community and has been referred to by many as a prominent immigration lawyer. So, when you're faced with those circumstances, now I want to be the first to tell you, we put Mr. Edgecomb on the stand yesterday. Now, we thought about not putting him up for a couple reasons. Number one is because the state hadn't even proven their burden to begin with. Mr. Edgecomb insisted, I want to tell my story. We promised you in the opening that we would have him up to tell his story. But Mr. Edgecomb was scared. The same fear that he had after he'd been hunted down by these two individuals. That same fear where he described as being the next Ahmaud Arbery. The same fear he had with turning himself into law enforcement and wondering if he could be taken into custody safely, as he described what he recalled from Sandra Bland. That same fear he exhibited on this stand yesterday. Now the state would say, oh, we can't trust this testimony. Well, let's talk about his testimony. Mr. Edgecomb, we felt it necessary to get out all the bad facts right away. We told you in opening, we're gonna talk about the good, the bad, and the ugly. I told you at the very beginning of the opening statement, there's 3 things. Mr. Edgecomb was not supposed to have a gun. He temporarily, not supposed to be in possession of a firearm at the time. We told you that. He's taking responsibility for that. You heard about bail jumping charges in this case. He's taking responsibility. We also told you that Mr. Edgecomb did in fact punch Mr. Cleereman. He never disputed it. You heard him come on the stand and take responsibility for it. You heard him come on this stand and say that if I could do this over, yeah, I was upset. Yes, I was infuriated. But if I had another chance to do this, I would simply accept being hit by a vehicle, thrown into another, What else did he admit? on direct examination. See, it's not easy. This is the first time that Mr. Edgecomb ever been sat in a witness box before. This is the first time he ever been charged with murder. These are serious charges. Who wouldn't be afraid? Especially in the city of Milwaukee, where you have amongst the largest incarceration rate for African American men. Of course, he had every right to be afraid. Now, you might say, well, why was his demeanor a little bit different with me than he was with the state? Let's talk about that. Well, first, I will tell you, when I first met Mr. Edgecomb, he was a little bit guarded, even with me.
Objection, Your Honor. As to defense counsel testifying as
Sustained.
he's not in front of the jury.
Sustained.
Mr. Edgecomb.
Watch counts the hyperbole.
Mr. Edgecomb has had fears. He going before a government where it's not popular to use that type of force against another race. Mr. Edgecomb, he was afraid of being tripped up. Now with me, he's a little bit more comfortable. He's got a chance to know myself, an attorney of mine, over the pendency of this case.
Defense attorneys claiming that Theodore Edgecomb was scared for his life in those moments, that he shot Jason Cleereman, and when he was on the witness stand yesterday. What else will this defense bring forth to this jury trying to save their client from life behind bars? We're going to take a quick break, but don't go anywhere. We'll pick back up where we left off inside that Wisconsin courtroom. Inside that Milwaukee courtroom, defense attorneys making their final arguments to the jury before they deliberate the fate of Theodore Edgecomb. We're going to pick up where we left off.
He understood that one wrong answer could potentially get him convicted of murder. So we talked about before that he has a diagnosis of attention deficit disorder. We don't want to play that up. He's a very intelligent person, but it's real. And sometimes the effects of that show itself when you're in a very highly stressful situation. Attorney Hubner, great attorney. There's times that both of us have had to exert a certain amount of aggression or a certain amount of assertiveness to get the evidence in this case. The evidence, it doesn't just present itself. Sometimes you have to dig, you have to keep going. And there were times in this case, if you recall, Mr. Edgecomb, was trying to complete a sentence that was not allowed to. He wanted a simple yes or no. Well, every answer does not result in a yes or no answer, but that's the position he was in yesterday. Now, Mr. Edgecomb testified. You heard him say. Now, Mr. Edgecomb had, if you recall on cross-examination, he talked about, the gun went off after he lunged at me. You recall that? He said it a couple times. Mr. Edgecomb believes that he's already made it clear that he shot Mr. Cleereman. He intended to shoot Mr. Cleereman to stop a threat. He did not, however, intend to kill someone. There's a big difference. So every question that discussed homicide or murder or blowing someone's brains out, of course, Mr. Edgecomb was taken back by that and did not want to answer a question in a certain way, so he kept resorting to, my actions were in self-defense. I acted in self-defense. Then he went, and he understood that part of your consideration, members of the jury, is to consider the reasonableness of his actions. We all know he shot Mr. Cleereman. We established that in opening statements. The question for you, though, is the reasonableness of those actions. Part of determining the reasonableness of Mr. Edgecomb's actions is when did he decide to shoot Mr. Cleereman? At what point did he decide to shoot Mr. Cleereman? That's the question. That goes to reasonableness. So Mr. Edgecomb kept reiterating, the shot went off at the time that he lunged at me. He's trying to explain to you the reasonableness of what he felt was at the time that he shot. He's not trying to imply that, this was just an accident. He's only trying to discuss the time frame. The shot went off after he lunged at me. Now, Mr. Edgecomb's no lawyer, not a doctor. He was on his way. I mean, he had just a few credits away from a psychology degree. He had a bright future. But we all articulate ourselves differently. Members of the jury, we're diverse people. The words I might say to describe something might not be the words that you might use. So we don't discredit Mr. Edgecomb based off of wordplay. So when he says, the gunshot goes off after he lunged at me, then he's followed by a very good aggressive question by the state that says, so it was an accident. So you killed him and it was an accident. Well, let's just think about that for a minute. Can you answer that in a yes or no? If he said yes, he just, that's what he ultimately said. Because he doesn't want to say, I intentionally killed Mr. Cleereman. Because remember, he never intentionally tried to kill anyone. He only intentionally tried to stop a threat. Techniques used by a good prosecutor. Please don't hold that against Mr. Edgecomb. Go back to your notes. See what Mr. Edgecomb testified to on direct examination. on direct examination, did Mr. Edgecomb not tell you? I went down the stairs. Then I went home. I put the gun there. You go to your notes. Did Mr. Edgecomb not tell you when I asked him? I was right here, and I asked Mr. Edgecomb, did you give the police your ID at the time you were apprehended in Kentucky? Mr. Edgecomb said what on direct examination? No. On direct examination, I asked him, did you give them a fake name? Did you give the Kentucky Police Department a fake name? What did Mr. Edgecomb say? Yes. I asked on direct, why did you do so? Go to your notes. He explained it. He explained it. Then on direct examination, I also asked Mr. Edgecomb, did the Milwaukee Police Department detectives come down and when they asked you about something happening in Milwaukee, did you say, what happened in Milwaukee? Mr. Edgecomb said, yes, I said that. Members of the jury, there was a follow-up question to that. Why did you say that? When Mr. Edgecomb was comfortable, he answered the questions. When he's comfortable, he did not hesitate to not answer one question. Fear is real. Attention deficit disorder, it's a disability. It's real. Anxiety is real. Being charged with murder are real feelings. Every other witness that stepped up here, if they had a bad day on the stand, if we got some information out or they answered a question the way that they might not have wanted to, you know what happens to them? Nothing. They go home. They have dinner, they get up to the next day, and that's it. Not when you're the defendant in a murder case. That answer could determine whether you're convicted or not. That's the reality. That's why before he feels like he's getting tricked up on something, can you ask the question again? Now, we talked a lot about, the fear. We talked a lot about, what happened on the stand, and these are red herrings. It's a red herring. It's a distraction. So now let's talk about the state's burden of proof. Let's discuss it. They have the burden. As the court has appropriately indicated, the defense doesn't have to prove anything. Though everything we came up and talked about, we showed you. In opening, we told you. We've shown that. So let's talk about the burden of proof.
As we approach the top of the hour, we have to step aside for a break. Don't worry, you won't miss a moment of the defense closing arguments on behalf of Theodore Edgecomb, who could spend the rest of his life behind bars. We'll be right back. Welcome back to Court TV Live. I'm Chanley Painter, where we are in day 6 of the deadly road rage shooting trial against Theodore Edgecomb. He's charged with killing immigration attorney Jason Cleereman after an altercation between the pair turned deadly. We had closing arguments earlier from the prosecution painting Edgecomb as a cold-blooded killer. And now the defense spending a lot of time trying to reframe that narrative, saying that when Edgecomb shot Cleereman, he did not intend to kill, he only intended to stop a threat. Which way will the jury go? Well, we still have more defense closings to get to, so let's do that now.
Now, as you see, the state has that burden. There's a lot of different thoughts that you might have. You know, when you get different parts of evidence, it might lean you one way or not. So it's important to understand that it's only the state that has the burden of proving something beyond a reasonable doubt. It can't be probably, it can't be maybe. So let's go through what the state's witnesses showed us. In fact, we actually like the state's witnesses. In fact, we would have, there's a couple of people that was noticed on the state's list that we thought were great witnesses, and we called them ourselves. A lot of proving reasonable doubt can be established just off the state's witnesses. For example, let's go to the first slide. So we discussed reasonable doubt. Again, it's not probably guilty, it's not guilt likely, none of that. All that will result in not guilty. If it's not beyond a reasonable doubt, it's not guilty. And at the end of this defense presentation, we're going to ask that you find Mr. Edgecomb guilty on all counts. We started with first degree intentional. You're going to see some lower charges that have been added. We're going to ask that all charges that you find Mr. Edgecomb not guilty. Let's go to the first slide. Mr. Rotrell Cameron. Now, this is probably one of the most memorable witnesses in this case. He's the only witness that was brought in with an orange jumpsuit. Mr. Rotrell Cameron, let's go over the highlights of his testimony. He stated that the incident was cold-blooded. He stated that the shooting appeared to be cold-blooded. That's why the state liked his testimony. That's what he was brought in for. Mr. Cameron testified that he was going to pick up his subpoena.
It seems as though there's something happening inside the courtroom. There was an abrupt pause. So we're going to take this time to talk to our reporter there inside the courtroom, who's been watching these closing arguments along with us, Joy Lim Nakrin. Joy, I know that you're outside the courthouse there, and first of all, what a dynamite morning of closing arguments from the prosecution, now the defense. There was this abrupt pause. Any word on what that may have been from?
It's not exactly clear what's happening, but it's some sort of apparent juror issue. We're hearing that deputies inside the courtroom were comforting a particular juror who I guess we should describe as an older white woman. Not clear if it's a medical issue, but of course we're working to get that information, and we'll bring you the latest there, Chanley.
Yeah, I hope everything is okay there. Thank you, Joy. But let's talk about these closing arguments, important moments happening today. What were some of those prosecution highlights that stood out to you?
Yeah, so you've done an excellent job covering what the defense is doing, and we've just heard from them more recently, but just kind of backtracking a little bit, the prosecution, just to sum it up in a kind of big picture way, is essentially arguing that this defendant started this fight and then ended it with a gun. They really did spend a lot of time during closing arguments kind of retracking the events for the jury, recounting the events as they see them for the jury. Let's go ahead and play a clip of closing arguments from Mr. Huebner.
What does the defendant do? I can't let them get away.
He gets on his bike, and he follows. He follows them. He goes right past the dynamite where he's supposed to pick up the sushi, doesn't care about this special night anymore. He had one thing on his mind. He was irate, and he wanted to catch up, and he sure did. And ladies and gentlemen, his own words to you tell you that this whole thing about him flying up on a car is a lie. Because he says, were you talking to me? He testified, well, he just wanted to see if they were going to admit to hitting him. But that never comes up. What he says is, I want to know if you were talking to me. And then he punches him. He punches the victim straight in the face. He punches the victim, causes his glasses to fly, causes blood to flow. And he gets on his bike, or stays on his bike, and just continues right around that corner. Now, ladies and gentlemen, yes, the victim put his hand on the car door and opened it and then closed it. And yes, he tells his wife to turn. And yes, they pull around and she stops the car. And he, the defendant, is now up on the sidewalk. And he continues to bike towards those stairs are. And then he stops. And ladies and gentlemen, you saw, yes, the victim starts off with that purposeful walk that several witnesses saw. And then, yes, even though some of them don't remember it, he got into that little bit of a jog. And he gets there and he squares up with the defendant. He's there, ladies and gentlemen, as Jose Perez and Jeff Parr told you, looked like he was going to confront them. His wife even said to the police at the time, yes, she said he was going to talk to him. She told the police he was going to confront him. Confronting could mean yelling at him, asking him a question, could be meaning to fight him, could be doing exactly what Rod Trell Cameron said he was going to do, which was get in that boxer stance.
And Chanley, this is a very different narrative, obviously, than what the defense had tried to advance. And big picture, remember in opening statements, Mr. Ivory was trying to tell the jury that essentially his client was acting in self-defense. But we may recall that during testimony, the defendant kind of muddied the waters himself regarding that particular defense.
That's right. And I did hear Prosecutor Huebner really take advantage of that in his closing, his first close earlier today, talking about now he claims it's an accident. Talk more about why that is such an important distinction here, Joy.
Absolutely. So, of course, Mr. Lamar, the defense attorney, has been articulating and trying to build this case that, yes, his client fired the gun, but he was acting in self-defense, that he did intend to fire the weapon, not necessarily intend to kill Mr. Cleereman, but he was acting in self-defense. And so during the line of questioning, during testimony of the defendant, there was a little bit of backtracking, I would say, because the defendant really painted a picture of an accident, describing how he said Jason Cleereman lunged at him and his gun kind of went off. His gun kind of went off. It was really an accident, which the prosecution has said is contrary to the idea of self-defense. And in fact, we heard the prosecution try to remove self-defense from the jury instructions for that reason, that, you know, their argument was essentially you can't have it both ways. It was either an accident or it was self-defense. It can't be both. Let's go ahead and listen to a clip of some of that testimony from the defendant himself.
And what was your intent? You're brandishing a firearm at a gentleman that's coming towards you. What was your intent at this time?
I didn't have any intent. This gentleman actually took one large step and lunged toward me like he was gonna tackle me. And I took a step back. And as I stepped back, it was the reaction from that, the firearm just went off.
And is it true that the only reason why you pulled the trigger is because of self-defense at a time that Mr. Cleereman lunged towards you with what you believe to be an object in his hand?
It was reactionary to him lunging towards me. Yes, the gun just went off. I didn't even, put any thought as to, the gun going off. It wasn't like intended. When he lunged forward, that's when I stepped back. And it was a reaction as far as like the gun just went off.
So you hear Chanley, the defendant, in his own words, describing how the gun just kind of went off, an accident, right? And again, a lot of the discussion between the attorneys outside the presence of the jury has centered around this distinction between an accident and self-defense. And of course, the defense fought hard to keep self-defense in the jury instructions. Chanley.
Thank you so much, Joy Lim Nakron, for those insights. We'll let you go for now. We really appreciate it. I'm going to bring in criminal defense attorney Jack Rice, still with me, and now joining us, civil rights and trial attorney Krista Ramey. I'm going to bring Krista in first, new to the conversation. Krista, some key openings. The defense, I keep saying openings, but they're closings. The defense is still underway inside that courtroom. So what were your key takeaways? Let's start with the prosecution.
It's interesting from just a pure trial advocacy perspective. I was a little put off by the prosecution's first close. He is a very intense personality and a very intense in his delivery of his closing. But I thought his points were incredible and well, thought through. I thought he took great advantage of the inconsistencies in the testimony with respect to the gun going off on accident, and what it takes to form intent to kill. So I think overall, I think that the prosecutor did an excellent job.
Yeah, his story was easy to follow. It was digestible. Jack, I know we talked about this earlier, but the themes, so important from start to finish in any jury trial here, but definitely out of the defense so far, Jack, and the prosecution, who has the strongest theme for close that this jury will take back with them to that deliberation room?
The prosecution. They've made this point, and they said it 3 times, that we know that Theodore Edgecomb started the fight and then used the gun to finish it. And he made it very, very clear. I've been listening to the defense, and they're struggling. And one of the reasons they're struggling is because once they put their client on the stand and he talks about a mistake with that firearm, we have to remember that when you're using self-defense is actually something you have to prove. It's something you have to establish. And self-defense is purposeful. So in other words, I did this because I had no choice, rather than, oops, this was a mistake. And so that undercuts the power of the defense. Before that statement, what they could have said is they could have said that Jason Cleereman, a drunk Jason Cleereman, chased Mr. Edgecomb up Bailey, down Holcomb, cornered him at the top of the stairs, and then lunged at him in the dark. What can he do? Now, there's a strong argument. There's a strong statement. You can't make it when you say, oops, it was a mistake.
Yes, and I almost wish Mr. Lamar, right out of the gate, would have painted that, just a short narrative of what you just said from the get-go, and then he can start explaining away why Edgecomb was so nervous on the stand yesterday and try to kind of make up for some of the fumblings, if you will, of his testimony yesterday. And I'm glad, Jack, that you made the distinction here that usually the defense has no burden in a case whatsoever, but because they have this affirmative defense of self-defense, they have an extra step to go to assert it here, and that's why they put on 10 witnesses over the last couple of days for the defendant, including the defendant himself, to testify. Krista, let's take a little look back to yesterday, to the defendant's testimony. Did he do himself any favors?
But we all articulate ourselves differently. Members of the jury, we're diverse people. The words I might say to describe something might not be the words that you might use. So we don't discredit Mr. Edgecomb based off of wordplay. So when he says, the gunshot goes off after he lunged at me, then he's followed by a very good aggressive question by the state that says, so it was an accident. So you killed him and it was an accident. Well, let's just think about that for a minute. Can you answer that in a yes or no? If he said yes, he just, that's what he ultimately said. Because he doesn't want to say, I intentionally killed Mr. Cleereman. Because remember, he never intentionally tried to kill anyone. He only intentionally tried to stop a threat. Techniques used by a good prosecutor. Please don't hold that against Mr. Edgecomb.
Sorry about that, Krista. You were starting to answer your impressions on the defendant's testimony yesterday, and I'm glad that we played that because his attorney spending a lot of time in closings trying to explain away why he may have been nervous or not to judge his certain word choice. We all have different ways of explaining things, Krista.
Well, first of all, I think that he's correct in saying that one of the most terrifying things that someone can be going through is sitting on a witness stand at trial when you're on trial for murder, right? And so it is you do fumble a little bit, but if you're explaining this much in a closing argument, what your client had to say while on direct and cross examination, then you're losing. It is a universal truth in the practice of law. If you're explaining, you're losing, because then you're just making excuses as to what was said and trying to persuade the jury to accept those excuses. It's like when a kid gets caught with his hand in the candy jar, right? And so you can't be explaining this much and win an argument.
Thank you, Krista Ramey, and of course, Jack Rice. We're going to squeeze in a break again. The courtroom in Milwaukee on an abrupt recess. There's some issue with a juror. Of course, we'll take you back in once closing arguments resume there in Milwaukee. But after the break, testimony resumed today in the federal trial against those 3 former Minneapolis police officers involved in the death of George Floyd. So we'll have a live report coming up next. This is Court TV, your front row seat to justice. Welcome back. In Minnesota, it is day 3 of the federal civil rights trial for the 3 officers involved in the death of George Floyd. Prosecutors are trying to establish a timeline of the case, calling a number of the same witnesses used in the state case against former police officer Derek Chauvin. Now, it is a federal trial, so cameras are not allowed inside the courtroom. So here to discuss, I still have with me Jack Rice and civil rights trial attorney Krista Ramey. We have Julia Janae there on the ground. We don't have a live report yet, but based on some of the notes that we're receiving from the courtroom, really this prosecution's case is echoing, reflecting the state prosecution case against Derek Chauvin. A lot of the same bystander witnesses, the body camera video being played. Krista, what are your thoughts on how this case, though, still may be a little bit different given that we have 3 different defendants?
3 different defendants that were present and aiding and abetting, not committing the acts that Derek Chauvin was committing. It's going to be a very different trial, even though you have similar witnesses. You're a federal civil rights trial. This is not an intentional homicide trial. So it will, the way the evidence is presented and comes in, it will be a little bit different than it is in the state court action, even though it's the same witnesses and the same evidence. It just will be packaged differently for the jury.
Absolutely, and we're going to switch gears again because the judge is back on the bench in Milwaukee, Wisconsin for closing arguments to resume, hopefully, for the defense here. Let's watch. There is a pause. Maybe they're waiting for the jury to be reconvened to walk into the courtroom, but as we have our cameras on him, that is the defendant, Theodore Edgecomb. I believe I hear the judge. Not talking quite yet, but I still have Jack Rice, of course, and Krista Ramey with me. Jack Rice, what do you think now moving forward? The defense has one opportunity, one time to make a cohesive closing. They've been up there for a while. What would you at this point suggest that they do differently or maybe the same moving forward?
Well, I think they're stuck, and that's really part of the problem that they have. They're really stuck based upon the statement that was made by Mr. Edgecomb himself. I think they still need to come back, and they need to make that strong theme that basically describes how he was chased up Bailey, how he was chased down Holcomb, how he was pushed to the corner of the top of those stairs, and when somebody is racing, running at you in the dark, what happens if you get hit? What happens if you get pushed down those stairs? How much could you be injured? Could you be killed? All of those things need to be made to say, I had no choice. Yes, it was a mistake. It was a mistake because I didn't want him dead, but that's different, fundamentally different.
I agree with you, Jack. I did hear the judge. I couldn't make out what he was saying, but while they're still sort of in this holding pattern, we're going to squeeze in a break. Don't go anywhere. You won't miss a moment of closing arguments in the Theodore Edgecomb trial here on Court TV. Welcome back to Court TV Live. I'm Chanley Painter, where court has resumed in the Theodore Edgecomb case. Closing arguments back underway, but to catch up on the juror issue from earlier, we have learned that the judge has dismissed that juror as an alternate, so she could go home. We have 10 jurors now, 10 women with 2 men, so that's the 12. But let's get back in there because the defense is not done yet arguing for Theodore Edgecomb.
Members of the jury, we were talking about the state's burden of proof in this case. And just a quick reminder, a quick review is that the defense in this case doesn't have a burden, have no burden whatsoever. And we discussed prior to the break that majority of the reasonable doubt that could be established in this case can actually come directly from the state's own witnesses. So we're gonna go through the testimony of the witnesses in this case, and we're gonna show it to you. We're gonna show you reasonable doubt in that they cannot satisfy this burden of proof. Let's go to the first slide. So the first witness, we discussed Rotrell Cameron. Well, he was one of the state's first witnesses. And what Rotrell Cameron testified to is he described witnessing the shooting occur, and he described it as the words being cold-blooded. Cold-blooded. He used those words. Now, that's why the state liked Mr. Cameron. That's why that's why he's essentially almost their star witness. He's the one witness who could testify outside of Ms. Cleereman, outside of Mr. Edgecomb, who had witnessed the last 2 incidents that occurred. So we know there was 3 incidents. We know that something started this. Mr. Cameron witnessed the last 2. He described the last final incident as being, it was cold-blooded. Now, what was interesting about Mr. Cameron's testimony is that immediately after he described it as being cold-blooded, he testified that the defendant appeared to be in shock afterwards. Those were his words. He said he appeared to be shocked. I don't know how many cold-blooded, heartless, violent killers are shocked after they shoot somebody intentionally. But that was Mr. Cameron's testimony. So what happened? You seen the state, after they worked hard to get this witness here, you seen the state jump up and start trying to impeach their own star witness. You remember? Do you recall? Mr. Huebner was right here. He said, well, you never said anything about him being in shock before. You didn't tell the detective, the officer, that when he was on the phone with you in the patrol car, you didn't say he was shocked. Remember that? Go look at your notes. That's not consistent with being a cold-blooded killer, the way they're trying to make Mr. Edgecomb to be. This is their witness. We didn't call him. Let's look at what else Mr. Cameron told us. He admitted, after the punch, he used a very key word. Mr. Cameron used a very key word when he described it. He was asked, did Mr. Edgecomb, after he punched Mr. Cleereman, did he withdraw from that confrontation? He said, yes. He was asked, was he a threat at that point? He said no. He admitted that Mr. Edgecomb withdrew once he got on his bike from that confrontation. Now, members of the jury, you're going to see that word withdraw or withdrawal again. You're going to see it in the jury instructions. It's going to be under the provocation. See, the state wants you to believe that, oh, well, let's see who started it. If you started it, you can't claim self-defense because you're the aggressor. Well, they forget about a very important word. It's called withdrawal. See, once you terminate and you provide notice to the party that you've acted aggressively with, you can regain your right to self-defense. That's the law. You're going to see it in the jury instructions. Mr. Cameron, their star witness, testified to this. What else did we get from Mr. Cameron? He admitted that Theodore appeared afraid when he turned the corner. He almost fell trying to evade him on the bike. Cold-blooded killer, violent, heartless, appearing afraid. Those don't even go together. This is their witness. They caught him on this stand. We asked him. So when he turned the corner, he appeared afraid. I said, when he went from the bike lane and jumped the curb, he said, well, he fell. He definitely appeared afraid at that point. When he continued going on the sidewalk, and when he went into this little stairway, he appeared afraid then too. He told you he was trying to go down the stairs. This is their witness. This is their witness. It doesn't matter how loud Mr. Huebner comes up and how passionate he is. These are the facts. Check your notes.
The defense closing arguments continues here on Court TV right after this quick break. Stay with us. Welcome back to Court TV Live. I'm Chanley Painter. Closing arguments in the Theodore Edgecomb trial underway. The defense still making its final appeal to these jurors before they begin deliberations. You haven't missed a moment of the defense closing argument.
Now, the state just came up and tried to make a big deal. Now, let's just get this straight. We started and we said this is a very tragic situation. Our heart goes out to the Cleereman family. This is a situation that escalated and it should not have. At some point, Mr. Edgecomb was responsible for a part of this incident. He punched Mr. Cleereman. He got upset because racial slurs was used based off of his testimony. or whether it was a swear word, whatever the case is, at some point, Mr. Edgecomb got upset. We know that. But at the end of the day, this situation escalated, and we're not trying to go back and forth and do victim blaming. That's not what this is about. As the state tries to indicate, they talked about, well, they said, oh, the wife, Ms. Cleereman, she was not hysterical, she wasn't acting a certain way. We, the defense counsel, never said that. You want to know who said that? Their star witness. Let's go back to Mr. Cameron. Mr. Cameron is who said that. Mr. Cameron described the wife's demeanor as calm, but he was hysterical. That's what he said. That's what their witness said. He said, I thought that was a bit unusual because I was hysterical. I was going crazy. I was on the phone with 911, but she seemed to be calm. We didn't put that at issue. Their witness did. So again, let's just put that for the record. Now, as we talk about different things that happen in this case, it is not to, blame anybody, but it's to show that Mr. Edgecomb cannot be proven guilty beyond a reasonable doubt. That's the purpose. We're showing all these things that appear suspicious. There's a lot of questions that are unanswered in this case. And if the questions are unanswered, they have not fulfilled this burden. This is not about, we've never met Ms. Cleereman. I don't know her. Either have you. So we don't know what she would or would not have done. We're not sitting there just trying to kill someone. All we're saying is that the possibility exists. And we don't know. So Mr. Edgecomb should not be convicted of murder because we have a lack of knowledge in that area. That's why we go through all these different aspects of the case that seem a bit suspicious or that warrant more explanation. Or we talk about the failures of law enforcement in this case, and the investigators, to not be thorough. And because of the lack of thoroughness, that's why these questions remain. And that's why, ladies and gentlemen of the jury, Mr. Edgecomb should be found not guilty on every single charge. Let's go to the next slide. Officer Patrick Tierney. Now, the state called Officer Tierney. Officer Tierney testified that initially
Your Honor, state did not call Officer Tierney. Defense did.
Gotcha. All right, my apologies. If the defense called Officer Tierney, my apologies. So the testimony that was elicited from Officer Tierney, he initially stated it was two potential witnesses that he believed wanted to give statements. But what did the video show? Remember? Remember the end of the video of his body cam? When he goes and he asks another officer and he says, hey, I see a guy standing over there. I see a guy standing over there. He looks like he might have seen something. Should I talk to him? The first officer says, we were wrapping up whatever he says, it was inaudible. So then he goes to Officer Mahalik, who's coming down. And Officer Mahalik, he says, hey, I see a guy over there. Looks like he has some information that could, in this case, I want to go talk to him. Here, which I believe was Jose Perez. He was in the video. We got enough. That's the evidence in this case. How? You never have enough of anything in a homicide investigation. Mr. Cleereman deserves a full investigation. Guess who else deserves a full investigation? Mr. Edgecomb. He deserves all the facts as well. You don't just jump to theories and rush to judgment. And at any point, this is 43 minutes after the incident occurred on the stairwell. 43 minutes later, you got an officer investigation. Then the evidence showed with Officer Tivenin that he was instructed to turn his body cam off. He asked, hey, are you live? Are you live? Think that's a fair assertion as to are you recording? Is your body cam recording? Think that's a fair deduction? And what Officer Tivenin does next is he says, should I cut it? He said, yeah. At that point, that's the end of Officer Tivenin's body cam. We don't know what happened after that. This is all reasonable doubt, members of the jury. Next slide. So now we come to Detective Tyler Kirkhope. Now, Officer Kirkhope.
The defense closing arguments returning to the theme that this was an incomplete investigation. The prosecution has not met its burden. And we'll take you back in for the rest of the closing arguments here on Court TV after this. Welcome back. Defense attorneys for Theodore Edgecomb still making their final appeal to this jury in his defense. It'll be the only time they have to make their arguments before the prosecution gets a rebuttal closing. Let's go back in and watch B. Ivory Lamar.
An item is removed from a scene, from a crime scene, it is compromised. That's what he told you. He talked about the duty of a first arriving officer to preserve the scene preservation. He talked about that's why you see the yellow tape immediately after a scene, because you don't want to have evidence tampered with. You don't want that crime scene to be compromised. Members of the jury, it's no longer an allegation as to whether an item was removed in this case. I told you in opening, we're gonna prove it. We've done that. Whether the admission was of a wallet or whatever the item was, an item was removed and the crime scene has now been compromised. That's just it. So how do you prove guilt beyond a reasonable doubt? We don't know. Again, we're not making any, listen, we have to put out theories. We don't know. I don't know any of these individuals of these parties. So, Detective Kirkvold said that no citizen, under any circumstance, should remove anything from a crime scene. It should be further investigated. Detective Kirkvold also said he can't confirm or deny whether an item was removed or placed at the crime scene. This is the lead detective. So what do? We go back to the burden of proof board. This is the detective. Can't prove anything beyond a reasonable doubt when your lead detective can't confirm or deny whether an item was removed or placed at the crime scene. We don't know. Again, it's not an accusation. We just don't know. We don't have enough information. Detective Kirkvold also testified that he doesn't know where the first incident happened and he didn't follow up. He also admitted when asked, I just thought that was unbelievable. The lead detective on the case cannot tell us where precisely the first incident occurred where Mr. Edgecomb and the Cleeremans had an altercation of some sort involving a vehicle. We don't know. The lead detective does not know. But then we asked the detective, we said, how long would it have taken you to ask Ms. Cleereman to get in a vehicle with you and have her show you precisely this is where it happened at? Sounds reasonable? He admitted it would have only taken...
Your Honor, mischaracterizes the statement that was by Detective Alvarado, not Detective Kirkvold.
That may be the case, but it's closings. Let's move on. Go ahead.
Stated it would take 5 to 10 minutes. 5 to 10 minutes to have confirmed. So we wouldn't be here a year and a half later, members of the jury, still not knowing precisely and exactly where even the first incident occurred. 5 to 10 minutes. They didn't do it on September 22nd of 2020. They didn't do it on September 23rd. And we asked, have you done it? Have you ever done it? In a year and a half that this case has been going on? No. That shows you the quality of the investigation in this case. Mr. Cleereman deserved better. Mr. Edgecomb deserved better. And that is another reason why the state cannot satisfy their burden of proof. Next slide. So members of the jury, we now remember where Detective Alexander Klabundy was called to the stand. I believe, if I'm not mistaken, that he was the state's first witness, I believe. And he testified that the knife found in Mr. Cleereman's pocket was a folding knife with a serrated blade, perhaps up to 10 inches in length. He confirmed that police never submitted the knife for DNA fingerprint testing. Here's the knife. You heard in testimony that other items like bottles, eyeglasses. Those items clearly would make it really hard to exert deadly force toward anybody, but those items were tested. Why was the knife not tested? He also confirmed that the White Claw can was never tested as well. The White Claw can that was in a back door, that can was never tested either. We don't know whose hands were on these items. And that, ladies and gentlemen of the jury, brings us back to our board. Burden of proof. Can't prove guilt beyond a reasonable doubt. Now, the state came up here and they talked about, well, his hands were bleeding. And his hands were, he came off the door, he got punched, he touched his face at some point. So that's kind of trying to indicate whether or not, the knife should have blood or anything like that. But remember this exhibit, Defense 11? This is the pants pocket of Mr. Cleereman. You see specks of something. Could be blood, could be dirt. We don't know. We just don't know. Now, does the state have resources to make that determination so we don't have to guess? Of course they do. This pants pocket could have been submitted to DNA as well. But it wasn't. And that, members of the jury, brings us back to the board again. Proving guilt beyond a reasonable doubt. We wouldn't have to speculate if the state would have done their job. Next slide. Now, it brings us to Miss Evangelina Cleereman. And again, our heart goes out to the Cleereman family. Now, let me just get a couple things clear. Just get a couple things clear. We understand that after, seeing or being involved in such a traumatic experience, one would tend to be distraught. That's fair. You don't know how you would react in a situation like that, especially involving a loved one. That's fair. Now, the issues that we bring are not to any way, blame, victim blaming or anything like that, as we just discussed. But when there's conduct which is somewhat suspect or it brings or begs a question, we have to present it. We have to bring it to your attention so that you, the trier of fact, can determine whether something has been proved beyond a reasonable doubt. So one thing I can say is that, there's several things in this testimony that, we have questions about, some of which, like I said, could be reasonable under the circumstances. But the state has not proven beyond a reasonable doubt. Her testimony is simply not reliable. It's just not, and we're gonna go through why. So it doesn't mean that, she's a bad person. It doesn't mean that, there's any type of issue. But it just means that simply because of those circumstances, her testimony is not reliable. Let's start. The first thing that she recalls saying, she said her husband said, "What the heck?" That was her recollection. She said, "What the heck?" Ms. Cleereman went and did media interviews.
We have to take a moment to thank Jack Rice for being with us this afternoon. And don't worry, you won't miss a moment of closing arguments in Theodore Edgecomb trial. Plus, we have breaking news out of the Supreme Court. Justice Stephen Breyer is set to retire. We'll have those details next hour. You're watching Court TV, your front row seat to justice. Thanks for being with us this afternoon. I'm Chanley Painter, where we are in day 6 of the deadly road rage shooting trial where Theodore Edgecomb is accused of killing immigration attorney Jason Cleereman after an altercation between the pair turned deadly. Now on day 6, we have closing arguments in the case. We've heard the first close from the prosecution painting Theodore Edgecomb as a cold-blooded killer who intended to kill. But the defense has spent most of the afternoon tediously walking this jury through what they say are holes in the prosecution's case. You haven't missed a moment of the defense closing. Let's go back inside court.
Mr. Cleereman said, "What the heck?" Fair. Now, on the body cam, we showed you in evidence Ms. Cleereman clearly saying, "What the fuck?" The issue is, it just goes to the reliability. This could indicate a tendency to water down a situation that was a little more severe than what it actually was. There could have been some things said we don't know. Ms. Cleereman also says she was looking at Theo in her rearview mirror. She also says she doesn't recall her husband opening a door after being punched by Mr. Edgecomb. Now, again, when you have a traumatic situation, I'm sure when Mr. Edgecomb came up, and I'm sure the state is going to come up, he came up, he violently punched him in the face, blah, blah, blah. We know that. But we have to now assess her recollection now and the credibility, because you members of the jury have to determine the veracity and the weight that you're going to credit her testimony. So what she testified to is that she doesn't recall the door opening when Mr. Cleereman looking to exit, likely to proceed after Mr. Edgecomb at that point. Now, generally when you open the door, especially at night, your lights are on, right? Her lights were on because you're going to see later that those same headlights were going toward Mr. Edgecomb. But when the lights were on, when you open the door, some cars, the interior light comes on. That would further be an indication that that door was open. Sometimes you might hear some type of noise when a door opens, a chime, if you will. So she doesn't recall that. And again, I'm sure it was a traumatic situation, but again, we have to determine how much weight. Some credit should be given to her testimony, absolutely. But how much do we give it? And that's where we go back to the board. This is how the state is improving their case. Guilt beyond a reasonable doubt? No. So let's go to the next slide. She said her husband told her to turn the corner because he wanted to talk to Mr. Edgecomb. But the video shows that she likely made an illegal turn from the middle lane to make that right turn. She also admits that Mr. Edgecomb was no longer a threat when he got back on the bike to leave. That's important. That's important. I don't know if you recall when we stopped the video, and you probably were wondering, like, what are they doing? And why is this point being driven so hard? Because we wanted to make sure that she agreed that Mr. Edgecomb was not a threat to her at the time he punched and got back on his bike. And that's why we asked questions. He said, so he's in front of you, right? Yes. You see the back of him, correct? Yes. And at this point, he's not a threat to you. She said, yes. That's important for a couple reasons. Number one, it shows that Mr. Edgecomb retreated, or the word that you're going to see in the jury instructions, he withdrew. That's the word that the state is not going to want you to pay much attention to. They want you to gloss over that fact. Withdrawal. That's what it is. He got on the back, he got on his bike, he proceeded forward, he turned the corner. That's notice that's imputed to the Cleeremans at that point. No doubt about it. The next point is she also admitted that she could have kept driving straight to go home. I don't know if you guys, members of the jury, I don't know if you recall, I don't see it here now, but we had a board that we referenced at a couple times in the trial. And in that board, we look, you turn right here, what's these locations here? And we asked, okay, so which way is home? And she testified that, yeah, this is the board. Thank you. So you remember the board, but we asked which way is home. And here's Brady Street. Here's the intersection where the X is. One of the witnesses during the course of this trial placed the X at that intersection. That's important. And she testified that home was straight. That would be the direction to go home. So Mr. Edgecomb had already made his right turn already. He already made his right turn. That's not a dispute. You've seen it in video. She decided to go take a right turn after Mr. Edgecomb, likely under direction of Mr. Cleereman. So when the state comes up and they talk about, he's a cold-blooded killer. He's a cold-blooded. He's violent. He's all of this. Mr. Edgecomb at this point now, he punched somebody. And the question you have to ask, did he have a firearm at the time he punched the first time? Did Mr. Edgecomb have a firearm on his person the first time he decided to punch Mr. Cleereman? Of course he did. Of course he did. If Mr. Edgecomb was a cold-blooded killer, why not take the gun out at that point and shoot at that time? Why? Why not? He was upset. And again, we said at the beginning and opening, there's no justification for punching anybody. Mr. Edgecomb should have called the police, let the authorities handle the situation. He should have done that, just as the Cleeremans should have done so as well. The state asked Mr. Edgecomb yesterday, they said, when you came down that stairwell, did you know it was a police department right there? Did you know it was a local police department right there? You know when they were grilling Mr. Edgecomb? When he was nervous? The same question applies to the Cleeremans. Actually, the Cleeremans would have gotten there faster because they had a vehicle to get there. They could have used the same vehicle they turned to go after Mr. Edgecomb to go to that same police station that Attorney Huebner came up and asked Mr. Edgecomb about. Could have went to the same police station, but they didn't. And that's, members of the jury, are why we're here today. They didn't. Nothing stopped the Cleeremans from taking a picture. How did Mr. Edgecomb get apprehended? They did great work using video to track him down. Just like they are tracking him down for a murder case as we're here today, they could have tracked him down for a simple battery case. A misdemeanor for punching Mr. Cleereman. They could have used the same technology to track him down for punching someone, but they didn't. That's key. Next slide. So, Ms. Cleereman also, confirmed that, she enabled her husband to pursue Mr. Edgecomb while he was on a bicycle. We just talked about that. She admitted that a gun was brandished by Mr. Edgecomb. She admitted she shouted out, "He has a gun," but says her husband did not hear her. Why is that important? If Mr. Edgecomb has a weapon brandished, that was his testimony, right? On direct, he talked about it. I had my weapon. He said it was around his waist area. He said, I brandished it. Well, can we, now I know, listen, we know certain parts of Mr. Edgecomb's testimony, you're probably like, okay, it's some part that, especially in cross, that, is questionable because he was feared. He was scared at that point. It wasn't me talking to him. It was somebody who's trying to convict him of murder. But when Mr. Edgecomb was asked, he said, yeah, I had the gun brandished. He said, I used my left hand and I said, stop, do not come any closer. That came out on direct. The gun was out already. The gun was used to deter conduct of Mr. Cleereman, but it didn't work. Even his wife, who loves him dearly, yelled out, "Jason, he has a gun." That didn't stop him. He kept coming. And ladies and gentlemen, that's why we're here today. Next slide. Two points here. Ms. Cleereman admitted that Mr. Cleereman got so close to Mr. Edgecomb, this would be invading his personal space. She admitted that her husband advanced toward Mr. Edgecomb. So initially, she testified that she seen her husband walking toward Mr. Edgecomb, which is fair. She pulled off and she used her vehicle to catch up with Mr. Edgecomb. And then she turns on her flasher lights in the bike lane. You've seen the video. So maybe it's fair that she didn't see a part of the jog as the state has described it. We consider it to be running or hunting someone down. But the more friendly term is jog. But nonetheless, we don't have to talk about words because it's just wordplay. We seen that yesterday. We talked about the testimony of Mr. Edgecomb. It's wordplay, just words, different ways people describe things. Ms. Cleereman described it as advancing toward Mr. Edgecomb. Nonetheless, the evidence now shows that it wasn't Mr. Edgecomb who was advancing toward Mr. Cleereman. Ms. Cleereman's testimony says it was her husband that advanced toward Mr. Edgecomb. That's why self-defense is at play. A cold-blooded killer doesn't run. How many cold-blooded killers run? Cold-blooded killers normally go after who they're trying to kill. That video shows Mr. Edgecomb running. Running, trying to save his life. That's her testimony. Next slide. Okay, we talked about that there was a warning first, then the gun, she touches. So then immediately after the gunshot, she goes to the scene. So immediately after her husband is now on the ground, she gets out of her vehicle and she goes to the scene. Now, you've seen the video. And
the defense attorney's closing argument for Theodore Edgecomb continues. He's going witness by witness, trying to raise reasonable doubt for his client. We'll take you back inside the courtroom right after this. Welcome back. Defense closing arguments still happening inside that courtroom in Milwaukee, Wisconsin. The defense attorney really trying to raise reasonable doubt, poke holes in the investigation, even going witness by witness from the state and the defense, trying to turn that to their side, fighting for their client's innocence. They say Theodore Edgecomb didn't intend to kill Jason Cleereman, but only meant to stop a threat. What do you think? Well, it's up to the jury. Let's go back inside that courtroom.
Vehicle within 6 seconds. And she goes over to the body, she reaches down, and I count it. It's 4 seconds. Count it. When you get in the jury room, go over to the video. Now, the defense has actually enhanced the video to try to make it more clear. You're gonna learn Mr. Edgecomb had to give $5,500 to have Mr. Mark Robinson fly in from New Jersey to testify about enhancing the video, because it's important that you see. This case is about seeing. It's not about just hearing different versions. Thankfully, we got A-class evidence in this case. Men lie, women lie, video does not. You got permission, members of the jury, to believe what you see. So when she kneels down for it, we don't know. She testified that she placed her hand on her husband's back to see if he was alive, then she ran back to the car. Very possible. We don't know. And neither does the state. We don't know. But that was her testimony a year and a half later. You know who didn't ask that question? The Milwaukee Police Department, when they were investigating this case. She was never asked. Why did you go out the first, why did you go the first time? There's no record of that. Now, we later learn, and we'll get into that later, that she goes a second time. Again, she retrieves, they don't say. She makes a 911 call, and she testified that she wasn't able to remember her PIN code initially. Very possible. Again, it's a traumatic situation. That's very possible. It's your mind, I can understand your mind not working the same, but so that being the case. However, at the time that Ms. Trotter comes on, she testified. She came right to this stand and she said that between the time that she got back in the vehicle and you see the red SUV come around, Ms. Trotter testified that she was on the phone with somebody. That's the testimony in this case. These are the confines of evidence that you have to consider. We don't know. I wasn't there. I don't know. Either does the state, and that's why we have reasonable doubt, because they can't prove guilt beyond it. You also heard in testimony that she said she wasn't in the car with Denise's boyfriend, who was an off-duty police officer. Then later she says that after seeing the video, she's like, oh yeah, I do remember him. The police officer, the off-duty police officer who came, Ivana's, boyfriend or husband. She's like, after seeing the video, oh yeah. She recalls that. Again, sometimes after traumatic situations, your memory can fade. That's possible. Our point, members of the jury, is that just the testimony is not reliable. That's all. That's it. No blaming anybody. That's reasonable to not recall certain things. Only thing is, the state has to prove it beyond a reasonable doubt. Next slide, please. So, she admitted that she did go to Mr. Cleereman. Now, this is all before the authorities arrived. This is all before Milwaukee Fire Department, Milwaukee Police Department, anybody gets there. It's just civilians at this point. She testified and admitted that she went back and forth to Mr. Cleereman while he was laying on the ground, not once, but twice. Then she admitted to removing a wallet from Mr. Cleereman, and here's the issue. We don't know when that wallet was removed. We don't know when the wallet was removed. She admitted of taking the wallet. We understand you want a piece of, okay. She said she wasn't interested in the contents of that wallet. Fair game. When was the wallet taken? We don't know. The defense does not know. Guess who else doesn't know? The state. Did the officers or the detectives ever ask Ms. Cleereman when she said, hey, I have his wallet, right? And then, remember, Officer During goes to Detective Kirkvold, and he said, I'm Detective Kirkvold, Tyler Kirkvold. And Officer During says, hey, I have her wallet. And he says, did that come up out of him? Go into it's in the blood, the body worn camera of Officer During. It's that video. And he says, did that come up out of Mr. Cleereman? He said, I think so. He said, that's a problem. Testified to that on the stand. That's a problem. The other detective next to him said, incredible. So what happens next? At that point, Detective Kirkvold orders Officer During, go find out where that wallet came from. Who got it? So you see on that video, Officer During says, okay. And now he goes and he asks Officer Mahelet, and he says, do you know where this came from? He said, no, I don't know. He said, I think the wife got it. He says, I don't know, or maybe MFD, Milwaukee Fire Department. Maybe they got it. So Officer During is shown on that video going to the Milwaukee Fire Department, individuals that are on the scene, and he says, did you guys get this wallet?
We have to squeeze in another quick break. Don't go anywhere. You'll pick up right where we left off for the defense closing arguments in the Theodore Edgecomb trial. Welcome back to Court TV Live. I'm Chanley Painter in Milwaukee, Wisconsin. Closing arguments continue in the Theodore Edgecomb case. His defense team really homing in on the wife of the victim in this case in her testimony. Let's go back in. You haven't missed a moment.
No, we didn't get it. No, we didn't get it. No, we didn't get it. Why is this important? Because that goes, it imputes notice to law enforcement. Notice is now imputed to the Milwaukee Police Department. And now that they know an item has been taken from Mr. Cleereman, it has been removed from the crime scene, at the very least, members of the jury, wouldn't you expect them to go ask Ms. Cleereman, well, why did you take the wallet? Why? Isn't Mr. Edgecomb entitled to at least understand why an item was removed from a crime scene in which the state is prosecuting him for murder? They don't even ask the simple question. And you heard testimony from retired Officer Browns who said that would have been standard protocol to ask someone why something was removed from the scene. And that, members of the jury, is yet another reason why we go back to our board here, burden of proof, because they can't prove guilt beyond a reasonable doubt. Too many questions unanswered. Too many questions never asked. Next slide. We have Ms. Stephanie Trotter. She admitted, and she said that it was weird that Mrs. Cleereman was going inside of Mr. Cleereman's right pocket. And we just talked about, she admitted that when she pulled up, when the two vehicles on a red SUV, when they pulled side to side, in that 1 minute and 34-second video, she admitted that she was on the phone and she was saying, Anna. So she was indicating that she was on the phone with someone. Now, let's go back to the first point. Ms. Trotter testified. We know she was there. We seen her on video before the video cut off. We know she was there. This woman was there. We know that. She called 911 while Ms. Cleereman was by Mr. Cleereman while he lay there. Ms. Trotter was very specific when she told you one thing, members of the jury. She indicated that Ms. Cleereman was doing something with the right pocket of Mr. Cleereman. The right pocket. The right front pocket. That was her testimony. The right front pocket. That was her testimony. I didn't make this up. She came on this stand and she raised her right hand like everybody else did in this case. Members of the jury, what was found in that right pocket? The folding knife was found in that right pocket. Let's discuss this issue. Let's just get it out the way right now. Are we saying that she put it in there, this and that? No, we don't know. We're saying we don't know. We don't know what she did with the right front pocket. I don't know if the wallet and the knife was in the same right front pocket. We don't know. They never even asked, when did you get the wallet? The question was never asked. That's why we have reasonable doubt here. If all the questions were asked, if we had the whole video, maybe we would have more information so that maybe the state could get up this ladder to guilt beyond a reasonable doubt. It's not there. Now, the state just said something in their opening. They said, well, Mr. Edgecomb is saying he's seen something in his hand. That's his perception. He believed he seen something at the time. Now, what you didn't see is Mr. Edgecomb come up on this stand and try to exaggerate a situation. He didn't try to say, oh yeah, it would be quite convenient for him to just come on the stand and say, oh yeah, I seen a knife. But Mr. Edgecomb didn't do that. He just said, I seen something. It happened so quickly.
All right, stay with us. You won't miss a moment of defense closing arguments in the trial against Theodore Edgecomb right after this. Welcome back to Court TV Live. I'm Chanley Painter. Defense closing arguments continue in the Theodore Edgecomb trial. Their last opportunity to try to convince this jury that he shot Jason Cleereman in self-defense. We also expect the prosecution to have a rebuttal close coming up too. So let's go back inside that courtroom.
Big right step, and then he lunged at me. So he couldn't really determine what was in his hand. That was his testimony. He also indicated that there was a second threat that he perceived, which was the vehicle. The same vehicle that hit him the first time, that knocked him on top of another vehicle, and where a racial slur was yelled out at him. The same vehicle that you saw, members of the jury, almost hit him a second time in the bike lane. Same vehicle. So at the time, Mr. Edgecomb's perception is these two threats. So he's not gonna exaggerate something just to make the story sound even grander. He has every reason to, because he's facing a very serious charge, but he took the same oath that every witness did. And he was advised, you don't exaggerate anything. You only tell the truth. So if you only believe that you've seen something, then that's simply what it is. We don't need to exaggerate anything. They still can't prove guilt beyond a reasonable doubt. Next slide. Now, that kind of brings me to, testimony that was provided by Ms. Cleereman when she said that they were out drinking And I always mess this name up, so you guys gotta forgive me. It's Scaffides or Scaffides, it's one of the two. But they were, wherever they were at that evening, she indicated that she had one glass of wine. And she indicated initially that Mr. Cleereman had 3 beers. That's what she testified to. Once I brought out, like, well, you know, based off of his size and weight, he's not a small guy. He's 6'3", 250 pounds. Not a small guy by any imagination. So when we presented the question to her and we said, well, you know, it showed on his toxicology a blood alcohol level of 0.12. And we question now, 3 beers? Now this is Wisconsin. We know, if we know anything about anything, we know about beer. And 3 beers, a 0.12? So then she testified and said, oh, well, okay, maybe it was 4 beers. Okay, maybe it was 4 beers. I don't know. The defense doesn't know. You know who else doesn't know? The state. But their witness testified that based off of that blood alcohol level, a guy with that weight, he agreed that 8 beers was more consistent with the blood alcohol level of Mr. Cleereman. And that was at 240 pounds. The autopsy indicated that Mr. Cleereman was 250 pounds.
Counsel, I lost track exactly, but you probably have about 10, 15 minutes.
Thank you, Your Honor. Next slide. So then we go to Lorenzo Hernandez. The assignment was to canvass 4 blocks between Houghton and Humboldt. He observed many video cameras going east on Brady Street, including 2 at Gloriosio's. They were all marked on the maps. This is diagonal to Dynamite. Evangelina said during her testimony, this is where the first incident occurred. He stated in testimony, he never was given a follow-up task as the investigation was turned over to the detective. Again, a lack of follow-up. Next slide. Dr. John Black, you know, what John Black essentially, you know, told us, he talked about selfies, and he talked about when you take a picture with a selfie and how, you know, when you focus on the one object, it's only after you actually get the picture, and then you notice some of the other things that might not have been in your perception at that very moment. You know, that's the same thing in this case. You know, so when you're looking at the video evidence, understand that everything might not have been within Mr. Edgecomb's, you know, perception at that moment. It was a heightened situation. It was, you know, obviously it was an intense situation. So again, that's something for us to consider. Next slide. All right, next slide. Go to the next one. All right, so that brings me to the next point. Mr. Edgecomb testified that he had 17 bullets, fully loaded. How many bullets were actually fired? 1. A cold-blooded killer that only takes 1 shot. He never shoots at the vehicle that struck him one time and almost struck him another. He never shoots when he could have punched, when he punched Mr. Cleereman. He doesn't shoot then. What kind of cold-blooded killer is that? Mr. Edgecomb testified that is after, you will see the step. You know, the state said, oh, he was just standing there and, oh, Mr. Edgecomb just pulled out the gun and shot him. No. Let's go to the video. Let's scratch. Let's go straight to the fence. Was it 15? D25. Members of the jury, this is the last time the defense will show you this video before you have it on your own to deliberate.
All right, we're going to have to squeeze in another quick break. You won't miss a moment of defense closing arguments as they try to save their client Theodore Edgecomb from life behind bars. We'll be right back. Welcome back. Just moments ago, we left off with defense attorney Ivory Lamar trying to counter the prosecution's narrative that his client, Theodore Edgecomb, is a cold-blooded killer. Let's pick up where we left off.
Jury, at this very moment, see, we use that word, withdraw. Don't forget that word. Withdraw cancels out the first incident. It makes the first incident, who cares what happened in the first incident at this point? It doesn't matter. It also doesn't matter, the second incident doesn't matter either, because of the word withdraw. This video at this frame shows withdraw. Could we play, counsel? Stop it right there. Mr. Edgecomb testified to the screeching tires that he heard. He testified to the heat from the motor that he felt on his back. He testified to just the loud noise and shouting coming from this vehicle. He's testified he was fearful at this very moment. Mr. Edgecomb didn't chase after them in the vehicle after he punched them, which he already admitted. He's not charged with civil battery. When you get that verdict form, battery is not going to be on there. If it was, Mr. Edgecomb would have took responsibility for that. He admitted it. Continue playing. At this point, stop. Back it up, please. And stop. Right there. That's the key frame of this case. You see that right step? That was the right step that Mr. Edgecomb described. He turned the corner, he made the right step, and he's lunging toward him. And when you heard the evidence, that's when the gunshot goes off after he lunged after me, Mr. Edgecomb's trying to describe the time that he believes makes his actions reasonable. The time of when the shot goes off. That's important. Not that, there was some accident, it malfunctioned. No. This was the time that the shot goes off. This is what makes his actions reasonable. This is why this jury should find Mr. Edgecomb not guilty because of self-defense in this case. Same plan. All right, let's stop that video, close it out. Now, Mr. Edgecomb has testified that he goes down these stairs, he goes home, you don't see him for 6 months. Now the state is gonna argue, that's consciousness of guilt. Remember in voir dire, Attorney Ahmad, he came up to the podium and he asked the question to you. He said, how many of you believe that only guilty people run? Remember that question? Only guilty people run. None of you raised your hands. And then the next question that Mr. Attorney Ahmad raised, what other reasons might there be that someone would run? In that jury room, there were several different people. They said, somebody could be scared. Somebody could be fearful of their life. Somebody could, especially as an African-American man, we still have issues in this country. I mean, listen, we talked about the cases. He talked about he believed he was hunted down like Ahmaud Arbery. He talked about the George Floyd and being taken into custody in an unfortunate situation happens like Sandra Bland. He talked about that in his testimony. We still have work to do. Now, the state, he also testified that he set up a GoFundMe account, that there was a GoFundMe account set up, and that he was trying to get a lawyer. They said, couldn't you just call one of your lawyers? Just because you have a lawyer on one matter, this is common sense. Use your common sense. Just because you have a lawyer on one matter does not impute an obligation for them to accept you on another matter. That's just common sense. He called lawyers. They told him $50,000 to $140,000. That was the testimony in this case. So just having a lawyer available doesn't mean you have the resources to get one. He was scared. He talked about that fear. So the consciousness of guilt stuff, that's a distraction. That's simply a distraction. If he's not charged with, just running, he's charged in this case with murder. If you want to charge him with battery, go ahead. You want to charge him with obstruction or whatever you feel like the appropriate charge is for not being available or turning yourself in for 6 months, do so. It's not murder. You got video evidence to make that decision on. Thank God for video. Look where Mr. Edgecomb is when there is video. He's still sitting here. That's why he's so nervous on this stand. He thought that the video itself should be enough. You see it with officers all the time. I thought it was a gun. It turned out to be a cell phone. But we understand, it was reasonable fear. oh, he looked like he was reaching for something. It's the same law. It's reasonable. It's still the perception that Mr. Edgecomb had. Now, I'm gonna wrap this up. Frederick Douglass once said, in a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny. And here we are, members of the jury, still embarked on that destiny. Mr. Edgecomb has accepted responsibility for his actions. We told you, he wasn't supposed to have a gun. He pled guilty to bail jumping. He took responsibility so that you guys wouldn't have to start your year off having to decide something that he needs to take responsibility for. He punched the guy. If he got charged with that, you're right. He should be charged with simple battery. He fled for 6 months. He provided his explanation for it. It wasn't because of what you've seen in that video. Any reasonable person would be fearful under those circumstances. Those are all true. But ladies and gentlemen of the jury, those are not charges that Mr. Edgecomb is facing. The charges that's going to be on the form that you're given is going to be murder. And a whole different multitude of degrees of murder. You got to go through that. That's what's on your verdict form. And that's why you need to find him not guilty, because they have not proven this case. Mr. Edgecomb is no murderer. He's a very soft-spoken, scared individual. Members of the jury, I want you to look at Mr. Edgecomb.
Objection, Your Honor.
Well, let's wrap this up. We're at about an hour and a half. The jury's had plenty of time to look at the defendant. Let's just finish with a couple sentences or whatever, counsel, and let's be done, okay? Please.
Yes, Your Honor. Mr. Edgecomb is no murderer. What he is, he's a survivor. He's a man who has already taken responsibility for any wrongs related to this incident, but today you decide, is he an imperfect person? The answer is yes, he's imperfect. But is he a violent, heartless, cold-blooded murderer? Absolutely not. Members of the jury, as the great Willie Geary often said, you have the power. You have the power, members of the jury. You can see wrong, and you can make it right. You can see suffering, and you can stop it. Members of the jury, Attorney Huebner is going to come again, another great attorney. He's going to talk about the rest of his arguments. Use your common sense. You didn't check it in when you came in this building. Use your common sense. And if upon doing so and applying the law to the facts, there will be only one just verdict in this case on all counts that have been on that verdict form. And that verdict, members of the jury, is not guilty. Thank you.
Defense attorney Ivory Lamar wrapping up his closing argument, saying his client's not guilty. He's not a murderer. He's a survivor. Who will the jury believe? Up next, we're going to take you back in court for the rebuttal closing argument from the prosecution. Thanks to Krista Ramey. We'll be right back.
eligible or to enroll. There's more for you with the United Healthcare Dual Complete Plan.
Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you for joining us this afternoon. Well, we have now heard closing arguments from the prosecution as well as the defense, but now we're going back to court. You haven't missed a thing because we now are waiting for the rebuttal to be delivered by the state. Let's go back to the courtroom.
Ladies and gentlemen, defense counsel stated that the state has not met its burden of proof. And then they didn't mention a single element. Not one of the legal requirements you have to take a look at here. Not one of them. We showed and proved that the defendant caused the death of the victim. We showed he did so with intent to kill. And defense counsel stated, oh, well, he's not a cold-blooded killer because why didn't he shoot 17 times? That's not the law. The law is whether or not he shot with intent to kill or practically certain to cause death. He took a gun that he's trained on, that he knows what will happen. He points it at the head of another individual, ladies and gentlemen, and he pulls the trigger and he puts a bullet in the victim's head. He says he's not a killer. He killed someone. That's what this is about. Ladies and gentlemen, Rebuttal Cameron didn't say he was a cold-blooded killer. What he said was what the defendant did was cold-blooded. He didn't mention any time, during any time, about the defendant looking shocked or in looking scared or any of that. Not when he's talking to the police. Ladies and gentlemen, when he was talking to the police in that 911 call, what was he doing? Begging the 911 caller to do. Get here. He's still here. He's still here. You can find him. He's got to go. He just shot him in the head. He was begging the police to find that man, the defendant. Rebuttal Cameron wasn't saying, oh my God, that guy looked really scared. You better go try to find him and make sure he's okay. He's saying, find him. I'm a person that just saw a man's head get blown off in front of me, and I want the person who did so found and caught. And he couldn't because he ran. And then he ditched the weapon. And ladies and gentlemen, we talked about a lot of things in voir dire. We talked a lot of things in voir dire. One thing we didn't talk, that defense counsel didn't mention, was that we also mentioned that your verdict has to be based on this case and this case alone. The defense, with the way they present their argument, is like a Chicago Bears fan talking about a quarterback. They'll talk about anything else. They'll talk about running backs or the 85 Bears defense, but they won't talk about what you're actually talking about because they don't have an argument. We bring up other cases. We bring up all sorts of other things. We bring up other things that have happened outside in some other place. Let's talk about here. Let's talk about what he did. Some injustice that you may feel that happened in some other case does not excuse or allow or invite an injustice in this case. What the defendant did was homicide. All of the elements have been proven. It was not self-defense. Ladies and gentlemen, even if, yes, you withdraw and he provokes, that doesn't mean he then is automatically in self-defense. A man comes up with no weapon in his hands, and ladies and gentlemen, be absolutely clear about that. This leaves just a few specks. The weapon, the knife, has no blood on it. No one says that knife is out. Not one single person says this is out. Defense counsel spent 35 minutes talking about a knife that's in a pocket that nobody sees come out. And says that is what makes it self-defense. Well, ladies and gentlemen, let's take a look at what defense counsel is saying. Your Honor, could you give me evidence control quick? Ladies and gentlemen, defense counsel is saying that the defendant was acting in self-defense because someone approached him. Someone engaged in his personal space. Someone had their fists up. Someone had a weapon that nobody sees. Ladies and gentlemen, at 1 minute and 26 seconds into this, all of those things apply to the defendant. He's got a firearm that nobody sees. He's engaged and invaded Jason Cleereman's space. He pulls his hand back. He's engaged in violence. He has violence intent in his heart. He's going to punch him. And if Jason Cleereman shot and killed the defendant right then and there, oh my God, would there be a different sort of circumstances and arguments coming from the defendant. It'd be a different super team of lawyers. I'd still probably have to run all their equipment for them, but it'd be a whole different thing. But you know what wouldn't change? Your verdict. Your verdict wouldn't change. Because at this moment, ladies and gentlemen, it's not self-defense. Bringing the identities and characters of who people are in an attempt to influence your verdict just goes to show you don't have an argument. If Jason Cleereman had shot and killed the defendant at that point, I would be here arguing the same thing, that he is guilty and the defendant is guilty. There was no weapon. There was no imminent threat of death or great bodily harm. He started a fist fight and then he ended it with a bullet. And I am just glad that finally at the end of this, the defense is willing to admit that the victim's wife loved him. Because for 2 or 3 days we were hearing about purportedly loves and why didn't she do CPR and oh my God, how cold she is. And oh, why didn't she get the wallet? She told the officers right at the beginning, it's on the body cam. She was asked on the stand, she got the wallet. The knife never came out. The defendant shot and killed a man with his hands up, worst case scenario, in a situation in which Jeffrey Parr states he shoots an unarmed man, in which Jose Perez states he shoots an unarmed man, in which Rodro Cameron states he shoots an unarmed man, in which the video shows he states and it shows that he shot an unarmed man, in which Evangelina Cleereman states that he shot an unarmed man. And keep in mind, defense counsel stated that she heard the defendant give a warning. No one hears that. Not one person. Not one person hears any of what the defense counsel is trying to say the defendant heard. Nobody hears it. Because it didn't happen. It just didn't happen. He started a fight and then he killed the man. Every portion and escalation of violence came from the defendant. Words, I'm gonna punch you. You wanna punch me? I'm gonna shoot you. And ladies and gentlemen, when you go through all of the elements like I went through with you and the defense avoided, you find that he's guilty. Negligence out. But I do think you should at least keep in mind one thing. Defense counsel spent about a half an hour trying to explain away his own client's words. The defendant could not have been more clear. He says the gun is pointed down. He states that the victim is lunging at his gun, by the way, or about to spear him, and the gun goes off. That's his words. Not, I shot in self-defense, not, I was trying to keep him away. I step back and the gun goes off. That is what he said. And defense counsel spent half an hour trying to make it seem that it's not what his client said. That is what his clients said. Because when that last-ditch effort by the defendant doesn't work, now the defense counsel's got to try Plan Z. Running didn't work. Ditching the gun didn't work. Lying to Kentucky didn't work. Lying to MPD didn't work. Lying to you didn't work. And now we got a whole nother plan. This case is what happened right then and there. And on that video, there was not a lunge. There was a step. Rodro Cameron says he has his hands up. Other people didn't see it. But regardless of it, the worst case scenario is a person who got punched was getting ready to punch back. And the defendant shot him. That is first-degree intentional. If you think he actually believed that there was a threat of death or great bodily harm, because that's what he has to believe, then it's second-degree intentional, because there's no way that's reasonable. If you think that maybe shooting only once somehow is not intent to kill, even though he's a trained weapons guy who's got a gun and at close range puts one into someone's brain, then it's first-degree reckless. If there's utter disregard for human life, if there's not, it's second-degree reckless homicide. Everything defense counsel just went through in terms of their arguments does not get you to not guilty. It's just a matter of which one of the homicides he's guilty of. Because there was not a valid self-defense claim here. Ladies and gentlemen, when you go through it, and you go through everything, regardless of whether or not they went and found something at Glorioso's, and keep in mind, defense counsel made a big deal of all this video, only to find out, and not mention at all in their closing for some reason, that the defendant says it's even further eastbound than that. Who cares about the swerve on video? It wouldn't have changed what happened when the defendant pulls a gun and shoots the victim. And their whole point for why that matters is Ricky Burns. Keep in mind, you are taking and hearing someone criticize an investigation in which they are doing everything they can, and he and they cherry-pick the evidence, cherry-pick the result, and Ricky Burns never asked for anything more. There were reports he didn't see and didn't even care to see. Why? Because they didn't want him to see them, because it didn't help what they wanted him to say. Talk about showing everything. They didn't. We called all the witnesses. You've heard all of the case. This is about this case and nothing more. And the simple fact that anybody tries to draw your attention to something else goes to show that they know they can't win when it comes to the elements and the facts in this case. He's guilty, ladies and gentlemen. The facts are clear. The law is clear. He's guilty. Your verdict is clear.
Thank you. Ladies and gentlemen, I'm going to read you a couple of additional instructions. The duties of the attorneys in the court have been performed. The case has been argued by the lawyers, and I have instructed you regarding the rules of law which should and must govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision in this case is to be thrown upon you, the jury, the jurors selected for this duty. You are not to be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate. Please be careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to render a just and true verdict. You will have the jury instructions when you go back immediately. You will also have verdict forms submitted to you. There will be eventually 5 verdict forms. The first one will read, "We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree intentional homicide." If that's your decision, you then answer the second question, did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Yes or no. The second potential verdict form that will be submitted is, "We, the jury, find the defendant, Theodore Edgecomb, guilty of second-degree intentional homicide in violation of the Wisconsin Criminal Code." Again, there will be the second question, if you find him guilty on that charge. Did the defendant commit the crime of second-degree intentional homicide while using a dangerous weapon? Again, yes or no. The third verdict form, "We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree reckless homicide in violation of the Criminal Code of Wisconsin." Again, if that's your verdict, You will have to answer the second.
The state just delivered its rebuttal and said there is no valid self-defense claim here. The judge is now telling the jury these are the charges. Go back and begin deliberations. We're going to squeeze in a break. When we come back, Joy Lim Nakran live will be with us from Wisconsin.